knowledge of an individual on patents, designs, copyrights, geographical indications, and trade secrets. All our past editions have received support from state and private universities and government institutions to further IP knowledge in the country. The exam is customized for people from different domains like law with IP specialization, law without IP, hospitality industry, research and science, etc. The various editions of IPTSE have been supported by several organizations that believe in knowledge-based economy, such as METI, NRDC of Ministry of Science and Technology, CPAM of Ministry of Commerce and Industry, AICT, iHub, etc. Just to share some statistics as to the impact factor that the initiative has been able to make. We've had around 200 plus awareness programs. The total signups from various editions are approximately 50,000 and approximately 25,000 exam registrations. We have signed around 40 plus MOUs with several educational institutions. Approximately 125 plus videos on our YouTube channel of IPTSE, and approximately 100 IP-related content on various social media channels of IPTSE. In our endeavor to proliferate participation of young minds to take IP examinations and its benefits, we have been upgrading the level of the examination, and now IPTSE has domain-specific examination and questionnaires designed by our team of sectoral experts. It will be a continuous exercise of IPTSE to thrive for excellence in the field of IP. I'm pleased to announce that year on year, we have been receiving greater participation from various regions of the nation, which has increased our presence nationwide. The theme for the 6th edition is Intellectual Property and the Futuristic World. As we embark on the journey to explore the intersections of intellectual property and the futuristic world, we are not only delving into the complex legal frameworks, but also envisioning the transformative power of ideas. In this age of digitalization, automation, artificial intelligence, and global interconnectedness, our understanding of intellectual property must adapt to meet the challenges and opportunities of tomorrow. It is interesting to note that as per the latest WIPO report, patent filing from India has increased by 36% in the recent year. Last year has also seen the highest ever GI registrations, and it is expected to double this year. Throughout the course of this event, we will have the privilege of hearing from experts, innovators, and thought leaders who will share their insights on how intellectual property is shaping the emerging landscapes of technology, business, and society. I want to express our deepest gratitude to all our speakers, panelists, and attendees for their participation in this event. Your collective wisdom and insights will undoubtedly contribute to a richer and more nuanced dialogue on this critical topic. Without further ado, let us embark on this exciting journey into the world of intellectual property. May the discussions today spark new ideas and foster collaborations. Thank you once again, and let us begin with the ceremony now. Thank you.
Thank you, Ms. Trivedi, for briefing us about IPTSE, and it is their endeavor to enroll as many individuals and institutions for this IP awareness exam and collaboration. Now, I would like to invite Ms. Sangeeta Gupta, Vice President NASSCOM, to share the welcome address. Sangeeta. I would also like to welcome Rajneesh ji from NIZD. So thank you so much for coming. So I would like to invite Ms. Sangeeta Gupta, Vice President NASSCOM, to share the welcome address. Sangeeta is an experienced Senior Vice President with a demonstrated history of working in the information technology and services industry. She is skilled in business planning, business intelligence, business development, brand management and business process outsourcing. She is a strong professional with a master's degree focused in economics from Delhi School of Economics. So, Sangeeta, over to you.
Thank you so much, Vandana, and a very good evening to all our delegates and my colleagues on the dais who are present here today. It's an honor and pleasure to partner with the CONCLAVE at the 6th edition of the IP CONCLAVE and the IPTSE Award. I think just hearing Ms. Trivedi talk about the journey of the awards and I think the vast support it has received across all facets of ecosystem, whether it's academics, whether it's the government organizations, whether it's corporates, I think it really brings to fore the importance of intellectual property and how focused efforts like IPTSE can help build an ecosystem of IP development in the country. I'm here today representing NASSCOM. So for folks who don't know NASSCOM, I'll talk a little bit about NASSCOM and the technology industry. NASSCOM is the industry association for the technology industry in India. And technology in India has been a significant contributor to India's economy. It is a $245 billion sector, almost 7% relative to India's GDP, provides a strong focus on employment with almost 5.4 million professionals. And for years, I think, the technology industry in India was known for its cost competitive advantage that it would provide to global organizations. But I think over the last few years, we've seen a shift happening. There is increasing focus on innovation, business transformation, and the role that intellectual property will play for India's competitiveness as we look forward. So NASSCOM had published a report on the World IP Day that tracked patent creation in India, and I think it showed that almost 45% of the patents are now in emerging technology areas of AI, IoT, cybersecurity, cloud technologies, etc. So clearly, I think for an industry which is very important today, it's critical for India, it's critical for the world and how we are partnering with global organizations. The importance of patents, intellectual property is very, very key. And what is it that all of us will need to do? So clearly, I think one, with emerging technologies like AI, and we were having a very interesting discussion just before the event started. I think with generative AI taking forefront, there's a lot more focus on what does copyright really mean? Who is the creator? What is the rights of the creator? I think we're going to see significant changes that lie ahead, and it'll be important for all of us to say, as we are building out these AI solutions or as we are using these AI solutions, how do we ensure that we are not infringing on a creator's rights and intellectual property? And I think NASSCOM's putting a lot of effort around saying what will be the right regulatory framework to deal with issues like this. I think the second is what IPTSE really is doing, build out the capacity in this country. How do we build more professionals that are really focused on IP development and get that understanding and awareness across the country? And I think third is really more awareness and branding about what is happening in India, what are the changes taking place in India. I was having a very interesting conversation with ma'am around traditional Indian practices and how that is now getting much more focus from a intellectual property perspective. So India is a very rich country across heritage and cultural practices, and I think if we can make sure that's really protected well, there's a lot to do. I know we have a lot of very esteemed speakers who know far more on intellectual property than I do, but I'd just like to say NASSCOM's very happy to be a partner to this program, and we look forward to taking this initiative forward. Thank you so much for joining us today.
Thank you so much, Sangeeta. Thank you. So today we have joining with us Ms. Gabrielle Mosler, Vice President Patent Development Ericsson. Gabrielle is Head for Patent Development within Ericsson, responsible for all patent creation and portfolio build-up, and in charge of a number of patent units worldwide with more than 200 people. Throughout the years, she has held several management positions and was responsible for European litigation within Ericsson for a number of years. So, Gabrielle, over to you.
Okay. Good afternoon, everybody, and happy to be here and nice to be here. And before I go into some nice words I heard here, but I just want to share, I mean, I'm working with Ericsson. Ericsson is a Swedish company. I look Swedish, but I'm not Swedish. I'm a German patent attorney and a European patent attorney, and I have the honor to be here, especially came from Germany all over to meet you all here for this precious award. But let me share some thoughts with you that I've seen. Thank you for joining us today for the 6th edition of the IPTSE Award and the IP CONCLAVE. We in Ericsson, we are very committed to the IP environment in the country and to the IPTSE initiative in a relentless step forward. I came here the first time several years ago, and I saw this country developing, and I saw how IP is really has a chance in this country to grow, and I'm so happy to see that this is really now happening. It's an honor to be here and see that India is emerging in the Global Innovation Hub and has scaled to 40th rank in the latest Global Innovation Index in 2023 released by the WIPO, from the 80th position in just the span of 9 years. I don't know if it was 9 years ago when I came here first time, but roughly. But already then, I'm not having a crystal ball, but it was very clear for me that this will happen, and I can just tell you it will happen more like this. India holds the 3rd position in the registration of startups globally and also has exponential growth in the entrepreneurial and innovation journey of the citizen of this country. We are also happy to note that India witnessed a notable rise in the world IP indicators. When I came here from the airport, I saw all over the places G20. And I think the G20 presidency has placed India at a phenomenal position of the international realm and has showcased the world how India is one of the most sought after nations. Something for you to build on. We are also pleased to notice that the overwhelming increase in Indian filings. India's domestic filing has surpassed foreign filing recently. Congratulations. Filings of patents has increased from more than 42,000 in 2014 to 15 to more than 66,000 in 21 and 22. That's more than a 50% increase in the span of just 7 years. What numbers do we see here? There also has been a significant increase in the patent grantings. It has raised from more than 30,000 in the years 21 to 22 to more than, it has compared up higher numbers since then. There are 420 registered patent facilitators that are supporting actively Indian innovator startups in the patent filings. And then also amazing to see the total number of registered patent agents in India stands at more than 5,000 people. These indicators are totally sufficient to prove that India will be able to showcase itself as the innovation hub by the time it celebrates the 100th years of independence in 2025. Hopefully I'm invited to come here. We at Ericsson offer our complete support, and we will be happy to work with DPIIT and IPO and the various academic initiatives. In this backdrop, there's absolutely no doubt that India will need more and more IP literate netizens in the field that can facilitate India's IP environment. The IPTSE, which is the talent search examination, is aimed at giving India such a talent pool. So it's a perfect place to grow this. We're extremely happy to know that there has been a significant growth of exam takers this year as against the earlier years. We can mention that with great pride that thus far this initiative has made 60,000 human connections, few of which also have opened up their own startup after having gone through the journey of the IPTSE, the talent search examination. Let's talk shortly about Ericsson. Ericsson as a company believes in innovation and creativity, and that it is a very reason to support this initiative. We at Ericsson, we hold over 60,000 patents worldwide. Our yearly investment in R&D is around 17% of our profit, which is around $5 billion US. And our revenues have made Ericsson a leading innovator and the driving force in the creation of each new generation of cellular technology. We are now starting to work on the 6G while we are just exploring and sending out to the market the 5G. Ericsson is very committed to patent quality. We support an industry patent quality charter which is focusing on quality and not quantity. Everybody can do quantity, we want quality. And I strongly believe that the IPTSE initiative has and will keep facilitating individuals in their career path. There has been 100+ individuals who have been given internship as a result. With the support of the law firms this year, we are very sure that there are many more individuals will be to benefit from the internship opportunity. I would like to thank the law firms who have come forward to support this initiative. We encourage many more of these industries, corporates, law firms to support it so that it can even be more impactful, meaningful, and holistic. And once again, let's thank NASCOM for associating with us on our CONCLAVE partner, Ministry of Electronics and Information Technology, National Research Development Corporation, and Punjab State Council for Science and Technology, and for coming forward to promote this noble initiative. I look forward to an interactive panel discussion that are planned, and I'm truly excited to witness the award ceremony that is just a couple of hours away from now. Many thanks to all of you, and wish for the program the very best. Thank you very much.
Thank you so much, Gabrielle, for your remarks and observations. We will now proceed with an address from Mr. Pankaj Soni, partner Remfry and Sagar. Mr. Pankaj Soni has over 20 years experience in India and the US. He's a mechanical engineer from BIT Mesra and MS in computer science and an MBA from Illinois State University. He obtained his law degree from Fordham University School of Law, New York. As a partner with India's oldest IP firm, Remfry and Sagar, he leads the firm's patent litigation practice and has litigated matters before courts in India and the US. He has advised Fortune 500 companies as well as startups on creating and managing IP portfolios and setting up effective patent protection and enforcement strategies in India, especially in the electronics, ICT, and telecom domains. So, Pankaj, over to you.
Good afternoon, everyone. And first of all, I'd like to extend an apology on behalf of our managing partner, Mr. Julka, who was supposed to be here, and I'm standing in his shoes for this brief introduction. Ashwin actually took unwell all of a sudden, and he had to cancel his appearance here. But if he was here right now, he would first of all like to thank IPTSE. Special thanks to Hitashi and Sheetal for actually reaching out to us. This is our first time being involved with this conclave, and I'm glad, and there are my colleagues here who are also present, and I'm glad that we are doing it. So kudos to you for doing this. We look forward to an engaging afternoon and the future. It's an honor to be here with such an esteemed delegation. The dais is filled with people who are far more accomplished than I am, so it is my honor to be amongst them and giving you an introduction. You've heard some numbers that have been thrown at you, and you will hear numbers in other discussions that will happen during the afternoon. I just want to add a couple points to that and sort of set the foundation of where I think we can add value as a law firm that's coming into this conclave. India is set to be the third largest economy by 2030. So in 7 years, you're looking at India being the third largest economy. Now, what does that mean? Or what does that entail? The cornerstone of that achievement has to be innovation and technology. And not only innovation and technology, but innovation and technology have to be integral parts of that achievement for us to get there. And this is a conversation that has been happening for a long time. I've been in this sort of profession for about 25 years, 13 years in India, and in 2010, when I came to India, there was a lot of conversation about IP. it's been on sort of a slow burner. But what we have experienced in the last 6 months, in the last year or so, and what we are hoping is going to happen is an exponential growth. The government has identified that. The fact that you have such a diverse delegate group here and a dais here tells you that people are thinking about this seriously. And it is going to be important for India as a country and for all of us as individuals. So 2 things. What does it mean for the youngsters who are here, for the startups, for the students, for the young professionals who are entering this profession? The future is very bright. The future is yours. And you have to use platforms like this to propel yourselves to get involved with the intellectual aspects of innovation and technology. My generation, when we started working in IP, a lot of it was by chance. You got into a field, you got pushed into IP, you were really not sure what intellectual property was, you were an engineer and they said, okay, we have this technology thing, let's push you in there, you started doing it. Now you have the opportunity to get into it knowing what lies in store for you, and the future is very good. So for anyone who's thinking, what does IP hold for me? Spend the next couple of hours today and thereafter to understand and to appreciate just how critical intellectual property is going to be for the growth of India, and your contribution in the fields of IP to take India there is going to be immense. So I will end with once again thanking IPTSE for this initiative that they have taken. For us to take IP forward, we have to educate the youngsters, we have to educate the school children and the young professionals and the people who are in university, and have them realize the importance of IP, the importance of making contribution to the innovation culture of India, because the government is recognizing it, the private enterprise is recognizing it, and I wish you all the best, and I'm looking forward to an engaging evening with all of you. Thank you.
Thank you so much, Pankaj, for your observation and remarks. I would now kindly request Ms. Gunjan Dave, Member Technology, Department of Telecommunications, to kindly share her expert remarks. Ms. Gunjan Dave completed her graduation and post-graduation from IIT Roorkee. She further pursued an MBA from Jamnalal Bajaj Institute of Management Studies in Mumbai. In 1987, she joined the Indian Telecom Services and dedicated more than 3 decades of her career to MTNL Mumbai, serving in various capacities. Throughout her tenure at MTNL, Ms. Gunjan Dave showcased her versatility by working across multiple units, including IT, planning, installation, broadband, mobile, and call center operations. She also held the position of area in charge. Her contributions were instrumental in handling the planning of new exchanges, telecom traffic routing, and the establishment of computerized digital trunk exchanges in Mumbai, as well as the introduction of radio paging services during the early 90s. With an extensive background in IT, Ms. Dave successfully implemented numerous IT-enabled systems such as customer relationship management and billing for mobile, network management systems for exchanges, and fraud management systems. She also played a pivotal role in software development for in-house usage, as well as the creation of customer-friendly applications. Notably, she was involved in significant projects including the Mumbai Wi-Fi, IT security audits, including SOX audits, and the management of MTNL's data center. From March 22 to April 23, Ms. Dave served as the senior DDG for Gujarat LSA, overseeing Gujarat and the Union Territories of Dadra and Nagar Haveli. During her tenure, she led the successful launch of 5G services in Gujarat and implemented the CBUD app along with other government initiatives. Continuing her upward trajectory, Ms. Dave assumed the role of Member Technology at DCC, Ministry of Telecom, starting June 1, 2023. In this prestigious position, she is responsible for initiating policy decisions, driving technological advancements, and strategic decision-making in the telecommunication sector. So, Ms. Dave, thank you so much.
Dear dignitaries on the dais, guests in the audience, and all the award winners, it's a privilege to be here amongst the so qualified and such eminent guests. As we know, the nation's progress is always catalyzed by its knowledge economy, which is driven by the creative capabilities and leverage of its innovation. IPR provides legal rights to protect and enforce the innovation and research for the innovators. A vibrant intellectual property ecosystem will not only enhance the economic development of the country, but also promote public welfare by protecting the rights of its citizens. Patents help in capitalizing IP through royalty fee and provide temporary monopoly exclusive rights. I would like to congratulate the organizers of this event for driving innovation and supporting the masses for a journey towards the transformation of India. In fact, in telecom, we have a Department of Telecommunication is also now promoting startups and research and development in a large way. And DOT has set up different funds also to promote innovation, R&D, and promote the IPRs. So we have in fact set up some 5G labs also, and we are in the process, we have also set up indigenous 5G test bed. This was towards the promotion of R&D efforts in the country, and when we have R&D efforts, it is very important that we are also aware about the IPRs and how to protect the research work and the patents that we have to register. So now in addition to that, we have also set up some funds, Digital Communication Innovation Square and Telecom Development Funds. These schemes are for promoting the ecosystem for research, design, prototyping, proof of concept testing, IPR creation, field testing, security certification, and manufacturing of products in the telecommunication field. And under the DCIS, DOT has supported 50 plus startups by now, and including MSMEs, and the initiative has resulted in the generation of 50 plus IPR in the next generation innovation technology. To further strengthen its position in the global telecom space, India aims to have 10% of the intellectual property rights in 6G technology, for which DOT has also launched a Bharat 6G mission, Bharat 6G Alliance, and test beds to promote research in 6G technologies. Outreach promotion, for that DOT, TC and CDOT are undertaking outreach programs to educate the public about economic, social and cultural benefits of the intellectual property rights for all the segments of the society, as well as the process of creating IPR and the values that result from it. Actually, it's very important that in all the colleges, in fact, we have to impart this knowledge, because so much of innovation and work is being carried out by the youngsters. But we have to really apprise them about the rights and IPR laws. So that is very important. And I feel that the organizers today, they are doing a very good job, and maybe they will focus on this part also. And it is an acknowledged fact that R&D and IPR development in telecom technologies is very complex, time and resource intensive. It is also observed that the shelf life of telecom IPRs or technologies in general is getting shorter, and new technologies are getting rolled out in and around 5 years. In fact, in telecom, every 5 years we start looking for the new technologies. So considering the pace of development of advanced features and new preparations for the next generation technologies, the research and development is already going on, and so IPR becomes all the more important. And specifically talking about the telecom sector, where standards play a critical role, and another important category of patents is the standard essential patent. SEPs, they claim an invention that must be applied by all companies to comply with the telecom standard, technical standard. And here also we have in fact appointed one nodal agency as CDOT to take care of this SEP part for the startup companies, because Many times they may not be using, they are knowing they are using some standards which are already registered in somebody else's name. So it's very important. Now, in fact, we have to see how we can collaborate with the telecom companies and in general other technical companies for the enhancement and for the awareness of IPR. In fact, we have a training center, and I suggest if possible DOT and the companies in general, telecom companies and other technical companies, whoever, technology companies, whoever are interested, we can organize awareness sessions on the generation of IPRs and its benefits in the telecom domain. We can have enabling mechanisms for categorizing the SEPs and frameworks to transfer technologies, IPRs in the telecom domain. And in the end, if industry and the IPTSE, we can collaborate together and we can see how we can have any structural procedural reforms if required, or any recommendations to strengthen the IPR regime ecosystem in India. Government of India is already doing a lot of work, and DPIIT is, we are in fact interacting with DPIIT also for reforms and making the processes simpler. So I feel today's conference is very, very important in this regard, and we are there to collaborate with all the partners. Thank you very much.
Thank you so much, Ms. Gunjan Dave, for your valuable insights. I would now invite Shri Rajneesh Kumar, Chief Operating Officer, NEGD, Digital India Corporation, Ministry of Electronics and Information Technology, for his expert talk. Shri Rajneesh Kumar is currently the Chief Operating Officer and Director for Capacity Building and Finance for National E-Governance Division, Digital India Corporation, Ministry of Electronics and Information Technology, or METI, Government of India. He has about 25 years experience in the railways and education sector. In 2014, he was awarded PhD in Mechanical Engineering in Industrial Management from Indian Institute of Technology, Varanasi. His keen interests are astronomy, puzzles, and mathematics. So, Mr. Kumar.
Well, thank you all of you for inviting me. And patents, copyright, as it is scared us. You add AI to it. So actually I am here very confused and talking to you on basically 4 points, because we will have to frame guidelines, rules, regulations. And I was talking to Mr. Harjot, I think just before he entered. I asked him this question, that if I generate art out of Delhi, does the art belong to me? Now, if I use Microsoft Word and do an authoring, the work belongs to me. So if I use a generative AI, does it belong to me? These are grappling questions. And the 4 areas where, where IPR, traditionally protected patents, copyrights, trademarks, and trade secrets, the interconnected world of data ownership has really brought many things to fore. For example, AI. Now, the conventional ownership of authorship and content is that a person who creates it is the owner. But in case of AI, if the ChatGPT uses several millions of text of research articles and gives me an output and I use it, does it belong to me? I can claim so. And there's a legal framework is going to be very, not scary I would say, but certainly it can pose a lot of problems to the creative people. Now, if I create music, art, or maybe written content, what happens to it? So this legal dilemma will have to be addressed very quickly, and I think it will take a few more years for all this to build up. Then blockchain technology has the reverse potential. Since we have blockchain technology, we can have tamper-proof records, and maybe have smart contracts. Then maybe the ownership which belongs to, say, a company who gives you generative AI, and the owner and the creator, how do you share revenue? So these are models which the governments will have to frame regulations and rules on. Then 3D printing disrupts the traditional technology. Now it enables replication, reproduction at far off locations, remote locations. Now what happens? This raises real concerns on copyright infringement. And the real challenge that comes is biotechnology. Now biotechnology, all of you heard of the Nobel laureate who made CRISPR. that can do gene splicing, gene editing. So what happens to the organism which is created out by biotechnology? Does it belong to the world? Does it belong to the creator of a new virus or bacteria? To whom does it belong to? And therefore, striking balance between innovation and ethics is going to be a real challenge in the next few years. Of course, if you have very strict laws on IPR, then the innovation is stifled. There will be some rogue country who will have no rules and it will thrive. It's like a nuclear disarmament. So you have to have nuclear arms to deter attack on you, but you cannot create nuclear arms because you are part of a peace process. So this area is tricky, but I'm sure with so much intelligence across the world and in our group here, we will find some solutions. So of course, there are some things like digital watermarking, blockchain smart contracts, digital rights management, and non-fungible tokens. All this will have now to be thought through in this group, and maybe in the next session that we have next year. You have it every year, so maybe by next year when we talk, we'll have some solutions ready. And all of you must have heard of this digital personal data protection bill of India. Now it is, of course, it has evolved out of several other laws of the world, but yes, startups and some agencies have been given exemptions out of it. But what is the exemption? How much is the exemption? All these are also very important for the IPR domain. So I'm sure the cyber law experts, the IPR experts, and all of us together will find some great solution. As I said before, I came confused. I will go back confused, but maybe next year our confusion will go away. Thank you. Thank you all.
Thank you so much, Rajneesh ji, for your valuable insights. I would also like to thank all the speakers for their valuable insights and remarks. As we are nearing the end of the inaugural session, I would like to invite Ms. Purvi Pandya, Director IPTSE, to extend the vote of thanks.
Thank you, Vanna, for flawlessly executing the inaugural session. Good evening, everyone. As part of Intellectual Property Talent Search examination, I wish to thank all the dignitaries on the dais and off the dais for the support and contribution in the field of IP and agreeing to be part of this conclave. I wish to express my gratitude and appreciation as we draw the curtains of the inaugural session of this intellectually stimulating intellectual property conclave. Today we have witnessed an insightful exchange of ideas, experiences and knowledge that has undoubtedly enriched our understanding of the pivotal role that intellectual property plays in shaping our innovation landscape. First and foremost, I extend my heartfelt thanks to each and every one of you for gracing this occasion with your presence. Your participation is instrumental in making this conclave a resounding success. The diverse perspectives, shared insights, and collaborative spirit that permeated through the discussions have contributed immensely to the depth and breadth of our understanding of intellectual property and its implication on innovation and entrepreneurship. I would like to express our deepest gratitude to our esteemed speakers who generously shared their expertise and experiences. Your expert views were not only informative but also inspirational, providing valuable insight into the evolving landscape of intellectual property and its impact on various industries. A special note of appreciation also goes to our sponsors and partners. I wish to thank our conclave partner NASCOM, knowledge partner CPAM of Ministry of Commerce and Industry, industry partner Ericsson, lead partner Remfry and Sagar, associate partners Lexorbis, K&S partners Singh & Singh, Qualcomm and TCS Consultancy Services. I would also like to thank our supporting organizations, NRDC of Ministry of Science and Technology, Ministry of Electronics and Information Technology, Punjab State Council for Science and Technology, and Center for Entrepreneurship Development, Government of Gujarat for the support. Your support has been instrumental in bringing together this community of thought leaders, experts, and enthusiasts. It is through such collaborative efforts that we can contribute to foster an environment conducive to innovation and protection of intellectual property. Once again, I thank every one of you for a valuable contribution and look forward to more meaningful sessions during the day. Thank you.
Thanks a lot, everyone. Thank you so much. I would once again invite Puri Pandya to take over as the MOC for the remaining sessions and the panel discussions. Thank you so much.
So moving ahead now, we will be having panel discussions on the most emerging and important topic of data protection impact assessment and intellectual property and the legal perspective. We have with us stalwarts from the industry and law firms to discuss on the subject today. This panel discussion will be moderated by Mr. Vishnu Mohan Rethinam, partner, Remfree and Sagar. I would like to invite Ms. Pooja Tiwari, partner, corporate and commercial Exorbis. A round of applause for her, please. Mr. Gurjot Singh, K&S DG Protect. Mr. Ashutosh Kumar, partner, Singh & Singh. And Dr. Vishwajanini Satgiri, head at CSIR, Traditional Knowledge Digital Library. So, just to introduce to our moderator, Mr. Vishnu Mohan Rethinam from partner Remfree and Sagar. Mr. Vishnu Mohan leads the firm's copyright team with more than 15 years of legal experience. His practice also focuses on contentious and non-contentious trademark work, including prosecution, opposition, cancellations, and appeal before the Trademarks Office and Intellectual Property Appellate Board. He has developed and implemented enforcement strategies, facilitated complex negotiations, and successfully argued several opposition cancellation cases and appeals for clients across a diverse spectrum of trade and industry. He also advises clients on emerging technologies, social media, and internet issues with a focus on IP and compliance mechanisms. He has authored several articles also and frequently delivers presentations on varied IP subjects and forums. His practice areas are mainly trademarks, copyrights, technology, media and telecom, and his education is his bachelor's degree in French, LLB, master's degree in business law. Over to you, sir, yeah.
Hello? Oh, wonderful. Thank you so much, Purvi. So, I'm actually thrilled to be part of this very wonderfully diverse panel. It's as diverse as the creativity we all need to foster an ecosystem where a knowledge economy gets prominence, and intellectual property is a very prominent part of that. So without further ado, what I'm going to do is I will introduce my fellow panelists. So when I was thinking about how to frame the session, how to make it meaningful for everyone, how to ensure that we all take away something from this 45 minutes to 1 hour session, I was actually struggling initially, and I was also very busy with work. But then when I looked at my panelist profiles, I think Hiteshi had sent me these profiles, and I was reading through these, and I figured out that, wow, my job is, actually I didn't need to really think, because my job is half done with the panelists themselves, because they're a very wide and wonderfully diverse set of people. And then it struck me that one could create a session, tap into their diversity and their backgrounds, and try and stimulate them to bring forth meaningful takeaways so that we can all go forward knowing where we stand today insofar as our country and its intellectual property regime and its data protection regime is concerned. Because there are lots of questions that come. We've just got a new law which has come into force. It's yet not in the, it's yet not up and running. It's not hit the ground running in that sense. So, what are we doing? Where do we stand? What does the law stand for? What led to its creation? Has it been created to suit where we stand today in terms of the interface of data, intellectual property and technology? Is it going to stand the test of time insofar as implementation, a subject where our country has often received a lot of, I won't say criticism, but a lot of microscopic eyes
Therefore, we all need to know exactly where we stand on the interface of data privacy and IP. And without further ado, let me start with Ashutosh. Ashutosh is a partner at Singh & Singh, and he's been there since 2012 with them. He holds bachelor's degrees in business administration and law and masters in IP laws from the University College London, where along with other branches of IP law, he specialized in the field of patent law as well as competition law and IP interface. So his work includes patent and competition law litigation. He has worked on various contentious cases pertaining to the field of patents as well as competition laws, which include the Novartis versus Union of India and the Ericsson versus Competition Commission of India cases. So Ashutosh, as his background suggests, will be tapped into from a enforcement, from a litigation, from a protectionary standpoint. I'm also joined by Gurjot. Gurjot is again a very unique part of the panel. He's a CIO or a Chief Information Officer, and as a cyber forensics and information security privacy specialist, he has over 25 years of experience working in diverse industry sectors. So he's been an integral part of brand protection campaigns for IT companies under the aegis of the Business Software Alliance, NASSCOM. He has a very unique skill set with a blend of law and technology incorporating cybersecurity, cyber forensics, and allied fields. So leveraging on this skill set, he consults on deployment of ICT infrastructure, information security, privacy frameworks, and on technology-related litigation. He's a lead auditor and implementer under the ISO 27001 certification, besides being certified on ISO 22301 or Business Continuity Management. Now, to my extreme right is Pooja. Pooja has a background in economics and law and over 20 years of experience in legal consulting, including corporate law and implementation of legal processes and systems. She has a proven track record towards delivering high-quality legal consulting solutions and enforcing processes under strict timelines of a demanding industry consistently. She's worked in various companies in retail, FMCG, real estate, tobacco, telecom infrastructure, and has handled aspects of domestic as well as international business, food safety, consumer matters, legal metrology, labor matters, structuring of transactions, due diligence of projects, and IPR in India and foreign jurisdictions, and dispute resolution through litigation, ADR, as well as mediation and arbitration. So she spent many years in the industry. I've known her before, we sort of cobbled this panel together. And she has varying experience in the real estate sector as well as in the retail sectors. And her work encompasses e-commerce, data security legislation, data handling, data storage, data protection, etc. She is a frequent writer on cyber laws in India as well as internationally, and has of course participated in many such panel discussions. And lastly, I have Dr. Sattigiri with me. I'm going to call her Vishwajanani. She's got a very beautiful name. And so she's again a very unique part of this panel. She is a scientist H and head of CSIR's Traditional Knowledge Digital Library Unit. So the TKDL is a tool for defensive protection of Indian traditional knowledge, not to be monopolized, correct? Currently, the Indian Systems of Medicine. She has initiated steps for expanding the scope and user base of the TKDL. So at CSIR, she's also handled matters pertaining to strategic planning, monitoring, and decision and policy insights. Prior to this, she was associated with the new drug discovery research at Ranbaxy Research Laboratories Limited. She led various drug discovery programs across various therapeutic areas. She was instrumental in progressing a drug candidate to a phase 2 clinical trial for chronic obstructive pulmonary disease or COPD under the GSK Ranbaxy collaboration. Later, she was working with a knowledge-based market consultancy firm, Smart Analyst, and where she was responsible for providing decision analytics support to big pharma and biotech companies in the US and Europe, working primarily in the fields of pharmaceuticals and drugs. So she has led interdisciplinary teams in various roles and has over 30 publications and 22 patent applications to her credit. So as you can all make out, so we've got a litigation perspective, we've got a corporate commercial perspective, we've got a technical perspective, and we've got a traditional knowledge perspective, very unique set of skill sets coming together today. I'm just going to trade off on all of them, not really going to speak a lot myself. I'm just kidding. So I thought actually that what we'll do is, we will start with one preliminary round of discussions where we will take frontline topics, and then I will tap into each of their domains for a more, or their backgrounds or even their former domains, for a more industry level understanding of where data protection merges with IP, how impact assessment of data protection is very relevant in each of their areas, with Gurjot's overall technical help on the kind of work that he does, and then try and put together a conclusion which leads us to the kind of takeaways that I was talking about before, which is knowing where we stand in this very, as Rajneesh ji put it, very confusing realm, and we hope that he was hoping that by next year we have the solutions. I hope, we have solutions sooner, and solutions that are dynamic and last as we move along. So without further ado, let me invite Pooja. So we have a data protection law. The government worked very hard on it. My personal view, after analyzing GDPR, after analyzing the current law, is that the government has made a very sincere effort to stay simple. It's made an effort to stay current. It has made an effort to set the foundation for what could be built on insofar as our data protection regime is concerned over the years to come. There is always a question mark on implementation and enforcement, and for that none of us have answers today. We will see how it all unfolds. But overall, the effort is not just concise and precise, but the language is very simple from a bureaucratic perspective. Even students sitting here, academicians, lawyers, consultants, technocrats, everyone can read through the law and figure out a very good, thorough, foundational understanding of where India stands and what the government is trying to do. So Pooja, so the law very clearly has these very fundamental tenets. The law says that, consent to store data, consent to take data from you and I, who are the principals, by a fiduciary, one who takes the data, it could be a vendor, it could be a service provider, has to be, there are 5 mantras, it has to be free. It has to be specific, it has to be connected to a purpose, it has to be informed, so the person giving the data must know that they are giving the data. It has to be unconditional and unambiguous, and it has to be with a very clear affirmation. So it's not implied, it's got to be explicit. So on that note, Pooja, I'm going to tap into your experience and perhaps ask you to start the discussion on obligations that we have with regard to taking and storing of data, and where exactly do companies stand on that ground today as we speak, when there is still, we don't know when the provisions are going to come into force and the law is in force. So where do things stand today?
Thanks, Vishnu. Am I audible? Okay. So you rightly said that the Act as it has been shared is still not giving us the rules. The rules have not come out yet, and it has been left at a level where a lot of fine tuning will be there once the rules are out, and we will know the exact way in which it has to be implemented. Till that time, we definitely have a window to kind of introspect and see what are the areas in which the companies can work, and where are the data collection points, whether they have the wherewithal to actually start implementing the Act once the rules are in place. Because a lot of people have this doubt that, data protection impact assessment is something meant for big companies which deal with, maybe social media giants need to do it, or maybe technology companies need to do it. But the fact of the matter is that each and every company needs to look into it. I will give you very small examples which show that how we are not at all aware of the data, the points at which data is getting collected. Simple example, when earlier, maybe 1 decade ago, 2 decades ago, a visitor used to come to a company, they would enter his name in a register and that was it. Maybe contact number also, address also, but that was it. And then once those registers got over and they were disposed of, that data got disposed of. In the past so many years, the tendency has been to enter everything into a computer, click a photograph, take the Aadhaar card details also. So you are actually creating a database which is never revisited. Nobody has ever tried to find out whether for what duration this data is being stored, whether it is actually needed to capture so many details for a person who has maybe visited just once, or is he really likely to, and every time he comes he has to share it. It is not that once it is registered he will not require to share that data. So these are aspects where when a data protection impact assessment has to be done, first and foremost the company has to realize the places where they are collecting the data. Then only when you are aware of it will you actually be able to judge. You conduct an audit and you judge whether you need so much information which is being captured at that point, and for how long you want to keep it, and whether you are deleting it or not. If you are not deleting it, where is the consent to keep on indefinitely such information? Because if you create databases, you are actually creating a possibility of something getting leaked at some stage. So instead of having a compliance cost attached to it, it may also be wise to revisit such points of data collection which can be kind of revisited and checked. Then another aspect within companies, there are interviews which happen. Interns will come, fresh recruits will come, and even interviews at senior levels may happen. One candidate gets selected or a handful of interns get selected, rest of the CVs are roaming around all over the system. Nobody who has business also will know about who is doing what is his complete profile. There are printouts lying on the printer, and I mean the information is all over the place. Now if that person has been hired, then also that data has to be protected. But that protection can happen only when there is a system to check where all it is available, whether there is some communication which is going that yes, these have to be deleted, whether any consent is being taken. I mean, right now you don't need that consent, but subsequently some kind of system has to be built in, that why are you retaining these, or if it is being carelessly left around, then what is being done to curb those kind of things. So actually an audit is needed to first know where are your data points, what is being collected, and this is something which applies to all companies. It is not about one particular kind of industry or any technology intensive industry or a call center only. It is applicable across board. I will give you more examples along the way. Right now I believe if you want to discuss it with some other aspect, otherwise I can take up a couple more.
So one of the very interesting facets is that the obligation is cast on every company. A question that I wanted to ask her and actually put her on the spot is, especially given her experience, and perhaps you can answer this in the second round, when you actually talk about your experience in the real estate and the retail sectors, is will they actually do it? I mean, will large companies actually implement measures, cogent measures? Will they actually outreach and put the effort in to reconfirm consent from every user of their products and services? And I will leave that answer for a little while later, because now I want to bring Gurjot in, simply because he's the techno-legal expert here. And obviously with his experience, he can tell us whether, let's assume all companies have the intent to do it. I mean, are they actually doing it? Are they actually investing in the kind of effort and the resources that they need to get compliant with the law as it stands today?
So just to answer your question, we couldn't get on a call because I was traveling the last week, and I usually stay in one brand of hotels, so they have my data on record. So this time when I was checking in, they said that, so India has a Aadhaar card, which is the Indian national ID. So they had a whole long form which they presented to me and said that we can, we need to take your data afresh, and the Aadhaar card is not something that we will accept as your ID card. I said, why? This is like sanctioned government, approved ID. They said, no, we have implemented the new law, the DPDPA, and within that, the Aadhaar card now does not stand any ground in terms of your identity. So will you please give me your driving license? And the driving license data is much more fluid than the Aadhaar as it is protected. So imagine me standing there, an implementer of the law, being told that the law has already been implemented by them and giving me directions in terms of how the new law is going to be implemented. So to answer your question, people have already done it. Okay. How? They have no clue. So the first line in terms of the, the front office, they have implementation guideline and they are just implementing it. They have no clue in terms of what they are doing, what the purpose for this is, how this will impact the overall strategy. Somebody gave them advice and they have gone and done it. So now this is as far as have they done it. So some of the people have already done it. What they've done, they don't know. But to supplement what Pooja was saying, when you actually look at data protection and if you look at the global level at how it is being implemented in California, in the EU, what you will eventually realize is that data privacy and data protection cannot be done independently only by policies and procedures if you do not have a bedrock of good, strong information security. Because the various principles of data privacy, where you need segregation of duties, you need to only have data presented to the people who will actually need to see it. If you need redaction of data, if you need anonymization of data, these are all very good in terms of policy. But to actually do these, you need technology. And the technology can only happen if you have an underlying information security infrastructure. So if you have a good bedrock of that, you realize that the data which is being collected right now is in silos. Your accounts or your finance will be collecting data in terms of how to make payments out. Your marketing department will be collecting data in terms of how to communicate new offers to you. And both of these departments are not talking to each other. How they are collecting the data, for what purpose they are collecting the data, how long they will keep the data, there is no synergy. So alluding to the fact that there has to be an audit, yes, there has to be. Does it need to be a DPIA? I think we are far from it. Right now, we just need an audit to understand what data is being collected, where it is. The impact in terms of which jurisdictions you work in and how you have to comply with all of that, that is far in the future. And as our law right now suggests, most of it reads like a stencil. We have everywhere where it gets complicated, it says will be prescribed or as prescribed. So we have a very good stencil of a law where everything will be done by guidelines so that we don't have to go to the parliament every time to get it sanctioned. So that's a unique way of putting it across, but then the other aspect is that we can also have industry, bodies coming together and so we can have representations from industry bodies which can say like there will be very different kind of requirements from
Usko band kar do. Just maybe if you shut that off, you'll have the feedback. No, mine is working. You're welcome to.
Yeah. Now can you hear me? Yeah. I think I've spoken way too long now. So you see, like in the pharma industry, there's going to be a totally different requirement in terms of because they do. Okay. That's off. No. Now, okay. So the pharma industry will have a different set of requirements in terms of how and what data to protect. India right now is also known as the dispensary of the world in terms of the amount of medicines that we are building. So the corollary to that is that we're also doing a lot of clinical trial on drugs. That means the common man is being used, and how and what data is eventually going to be captured and how it's going to be captured. So it's a new and interesting field. A lot of things will happen as a consequence to what the European Union has done and what California has done, what Canada and Australia have done. But ultimately, we'll see how this all applies and what jurisprudence builds up in terms of the protection of the individual. Over to you. Yeah.
Thank you so much, Gurjot, for this starting introduction on where the companies stand insofar as the kind of technological bedrock that they need, and information security is very critical. Unless you ensure information security, you're not really doing anything to keep data safe. So on that note, what I want to do is I will end with Ashish in this round. I had initially planned it differently, but that's just the way we move in these discussions, and you sort of, you're on the spur of the moment, changing or casting it differently. And I want to, introduce, Vishwa Janani's work, because she is in charge of a very unique body of work, and her experience in sort of understanding the issues of data privacy in the body of work that she handles is very relevant, because it's a very different kind of work. It's not corporate, it's not commercial, it's not client centric, it's not, in the sense that it's not vendor and customer centric so much as perhaps the retail sector or the pharmaceutical sector would be. So, we all are aware of the traditional knowledge digital library. It's a wonderful initiative of the government in protecting traditional knowledge, from being patented or being monopolized. So the database has also been exemplary in its structure, format of data inclusion in creating digital content. So as per the national IPR policy, we're also looking at introducing oral traditional knowledge. So I wanted to ask her to sort of shed an initial light on the kind of data protection impact assessment and the IPR merger, or the kind of ecosystem that she sees in, and how her institution is like poised to look at this law and see how it impacts them. So over to you.
Yeah, I think it's okay. Thanks, Vishnu, for the introduction and the lovely discourse that we had. Thanks to Hiteshi for giving me this platform. Thanks, Sheetal, too. So yeah, as Vishnu just mentioned, my work is very different, and it is about protecting data from the point of knowledge. So as you would all appreciate, data is just the starting point for generating knowledge, and thereafter wisdom in the right context. So what is it that we do? I thought I'll share my experience a little bit and then kind of touch upon this security breach and the safety of information. So the traditional knowledge digital library that I had is a very unique initiative from the government of India in the context of patents being filed on haldi, basmati, neem, and many more of those such kinds. So what we had then realized is, we need to protect our knowledge from misappropriation or piracy, to put that. And we wanted to create our information in a format that is accessible and understandable by foreign entities, the patent officers basically, so that they do not grant IPR on whatever is already known in our traditional literature. So the way we had structured and created the format is very unique. I would urge all of you to go visit the TKDL website. We had converted, I would say, transcribed the information from our traditional text into English and 4 other foreign languages like German, French, Spanish, and Japanese. And the best part of it is that we draw concordance between the traditional terminologies and the modern terminologies. And it is all a codified way of making this information available to the patent officers. We created what is called the TKRCs, Traditional Knowledge Resource Classification Codes, that forms the metadata of the database. And we draw concordance with the International Patent Classification Code so as to make it easy for the examiners to understand that. And the TKRCs, the metadata is confidential. You can do a search, any user, we made the database open to few of the formulations that we have included. And very frequently, as we understand data needs to be protected. Yes, it needs to be protected. Early threat recognition is very important. We do frequent third-party audits just to ensure that our database is safe. And the very other important point that we also look at is, in terms of backing up the data regularly. We have also created a DR site, and right now our information is all server-based, not on the cloud. So this is one way of protecting the information. And in the context of what Vishnu mentioned, the national IPR policy and also including the oral traditional knowledge, so far, as I mentioned, the information content in our databases from the text, which is already public domain information. We are taking care to protect even that data from being misused. But in the context of oral traditional knowledge, wherein the custodians of such knowledge are communities, individuals, okay? So when we are capturing that information, we would automatically include information on those communities, those individuals. So from a personal data protection point of view, that becomes important. So we plan to again use the digital ICT platform to see how to flag information. And here the key point that we are also looking at is the expressed prior informed consent. So the knowledge holder might be willing to share the information with us, but would say that, do not project more than this part of the information to the public, okay? So those flags and the balances and checks is what we intend to do. And I think it is a kind of a important step towards protecting data. So perhaps in the audits and all come thereafter. First just putting the foundation together very safe.
Wonderful. So, as you all heard, there are the first three experts talked about a more in-house, robust mechanism to protect the data. So, you had the technical expert weigh in, you had Pooja weigh in with her view on the relevance of companies storing the data, and you had, Vishwajanani weighing in with the kind of in-house measures that they've taken as part of being custodians of this very wonderful body of work that they have, which definitely, though not being monopolized, still merits a very high level of protection. So while in-house mechanisms are fine, I'm now going to move over to Ashutosh and, leave the floor to you. What if there is pilferage? What if there is leakage? What if there is violation? How do we protect it? How does, Vishwajanani, what does she do today if she's confronted with, leakage and theft? What does Pooja do, for example? Or, how does Gurjot interface the client and the legal expert to sort of bring some remedies to the table?
So thank you, Vishnu. I won't give specific legal advice to all these three. Yeah. I'll just give the general overview of enforcement remedies which are available in case of data breach. Obviously, for expert legal opinion, maybe we can discuss later.
Wonderful.
No, but having said that, see, we have various remedies available under law as the system exists today. But before saying what kind of remedies a company can avail in case there is a breach of data within their organization, we should know why there is a need to have a proper enforcement agency. And we all know now we have a Data Protection Act in place, and the penalties which are provided under that act are huge, from 10,000 rupees to 200 crores.
Yeah, that's like a very divergent set of monetary fines, right? There's 10,000 rupees for, if I do something wrong, but it's 250 crores for the company that does something wrong.
Yeah, so the penalties are like, the bandwidth is quite large.
Yeah.
Within this bandwidth, the authority will have discretion to impose penalty. But while imposing penalty, one of the factors which they take into account is, or which they will take into account, we don't know how it will be implemented, is what steps you have taken to mitigate the risk, or the steps you have taken to ensure there is no further breach of data. And that leads to your enforcement strategy, what kind of enforcement strategy you have in place. So the law before the Data Protection Act came into place, most of the data privacy issues or the data threat issues were being handled under the IT Act. So IT Act has some remedies. Apart from the IT Act, other remedies, availment of other remedies will depend upon the nature of data which you had and the relationship with the person who is alleged or who is accused of breaching your data privacy. So for example, suppose if the data set which have been stolen or which have been modified or compromised in any manner is in nature of a trade secret, then obviously your remedy is to file a suit for breach of confidential information. And if it's your ex-employee, then obviously you'll have to establish that relationship that person has access or an opportunity to access that kind of a data. Then that's more like a civil remedy, and at maximum you can ask for injunction that please injunct that person from using that data further or to disseminate that data further, plus along with damages.
So sorry, just to interject for a slight moment. So you had Pooja talking about companies having endless CVs and iris recognition data stored in their database. So you have a disgruntled employee who walks out, but another fine day after 1 month decides to create some nuisance, walks into a company, checks in using his iris data which is there, which the company has kept. So tomorrow if the company goes to court, can the court tell the company that, look, you've been keeping the data, you allowed him to enter, and therefore there is some level of due diligence lacking on your part? I mean, is that?
Like, certainly, look, that will be one of the factors for the court to determine the kind of damages which they will award. Suppose if you yourself was not that vigilant, obviously then the amount of damages may vary.
Correct. So I mean,
yeah,
what the guy's done is wrong, but ultimately I'm just talking about some kind of mitigation on the damages.
Yeah, so that may have some impact as far as the relief of damage is concerned, but not on the injunction part. Obviously, the court won't say because you were negligent, so other person has a free right.
Of course.
Yeah. So apart from these kind of a civil remedy, now recently we had the Supreme Court ruling in Jagjeet Singh case where the court said that apart from protection under the IT Act or civil remedy, you can also go for criminal remedy. So because suppose if again in the taking example of an ex-employee, if an ex-employee who has a responsibility to ensure the sanctity of data or to ensure the value of a particular data within an organization, if that employee uses that data set or any work product for his own benefit without authorization outside the scope of employment, in that case obviously that will amount to a certain extent criminal breach of trust, and we all know that our Indian Penal Code provide remedy for that. So remedy like theft or criminal breach of trust, those kind of criminal provisions can also be invoked depending upon again the nature of violation which is taking place. Again, apart from these two, like civil and criminal, when it comes to IP right, because we have a copyright act which says that the computer database and all, it's a part of again literary work. So suppose if a third party, a company or any other your competitor is copying your data or data set which is similar to your data, and then again you can file a suit for copyright infringement. So we have these different remedies available under the existing system where you can invoke these remedies to ensure that there is no further breach of your data.
Wonderful. That was very, very concise, Ashutosh. And let me just check the time. I'm mindful of the fact that we need to finish on time. We need to have the next session start on time as well. So the second round of discussions is again very structured. I've requested Pooja and Vishwajanani to talk of industry-specific impacts with her pharmaceutical background. She's agreed to take care of the pharma side. And Pooja, with her real estate and retail background, will take care of those two sides. But I will start in the reverse order this time. Ashutosh, have you had some international flavors coming in insofar as enforcement is concerned? We've had a lot of time with the GDPR abroad. And have you had any notable instance which you can think of or which you've read about or which you can share on how courts abroad have, looked at the enforcement side of data privacy?
With my experience, I can tell you, Vishnu, that before this Data Protection Act came into force in India, a lot of our clients, especially who are working in IT sector, used to have that query that now because we are processing data on a daily basis or we have these data sets within our organization. So how to deal with it? Because Supreme Court way back, I believe in 2017 or 2016, declared it as a right to privacy. It's a fundamental right. And a lot of companies are dealing with the data of so many individuals or so many Indian citizens. They are scared that someone may say that, no, you're violating my fundamental right, you're dealing in data in a manner which is not authorized. But the law came in just now. So at that time, just to be on a safer side, we used to advise them, there's a GDPR model which exists. You can take that as a model and frame your privacy policy on that model, so that in future, I'm sure even our country, we won't take a very different view when it comes to.
Correct. There's got to be some level of harmony.
Yeah, if you compare both the laws, the fundamental principle underlying rationale for both, a lot of provisions are same within GDPR. So at that time, till the time the law came into force, GDPR was being practiced in India in practice. It was like officially it has no legal value, but in practice a lot of company they used to follow that model. But now overall, if you see at a global stage, different jurisdictions have a different model when it comes to data protection. So for example, India before Data Protection Act came into picture, it used to have sector specific law. Barring IT Act, which has some provision which applies to, which was kind of a sector agnostic, which applies to different various sectors. But apart from that, we have the Medical Council guideline for medical related data, then Bar Council guideline, to deal with relationship between client and attorney, and hence so on and so forth. Similarly, US still has a sector-specific law like HIPAA for health-related insurance, then Graham-Leach-Bliley for financial, and then they have a kind of a sector-agnostic law, but that is restricted to one particular state, California consumer. And then remaining at a pan-US level, you have unfair competition law, which is left to the states how to implement that. The only kind of a comprehensive model which was there is GDPR, and now we have in India. But how it will be implemented, like we have seen in Europe, the European authorities are very proactive and very aggressive. We have seen Ireland data protection authorities ruling in case of Facebook Meta, where they impose a penalty of almost like 1.2 billion against Facebook.
Yes, very heavy cost.
Very heavy cost. Same was again Instagram, where they were because of some default change in settings, all the children's data become public. So again, they were penalized for that. So having in Europe, because the GDPR, I think now it's fairly an old regime, and people know how this being implemented. The authority there are also quite proactive. But in India, as Pooja and Rojot both mentioned, that most of the things as of now are yet to be prescribed. So we have to see how the Indian Data Protection Authority will, the Data Protection Board will implement it.
First, let it also come into being.
Yeah.
Okay, on that note, Gurjot, do you want to weigh in on what he was talking about vis-a-vis your techno experience with GDPR's, on the ground acceptance, and how do you think the Indian, DPDP Act will move forward?
So, see, the Indian IT industry is already GDPR compliant, because anybody who so much as picks up the phone and says hello to a European citizen, that company has to be GDPR compliant. Most of the companies who are Europe based and who have their backend data centers or their processing centers here are BCR compliant. That's, or they are SCC compliant. That means they have to follow the same rules which the GDPR imposes on the parent company in the European Union. So if you go to Bangalore and if you go to Hyderabad, where most of these tech companies are, where most of the innovation or most of the people who from European Union are being serviced, they are already GDPR compliant. The only thing that, and for that matter, all the Indian citizens who work in those companies also fall into the same category, and their information is compliant because the company is actually liable in Europe rather than here. So now with the DPDP Act, for them to migrate to implement for the Indian entity won't be much of a task. And I have worked with a lot of edtech companies who were servicing in the European Union and globally. For them, it was an easy task. The challenge right now, as he's, Ashutosh was saying, is that most of the Indian entities servicing Indian customers or Indian citizens, because they are oblivious of the fact, some of them are oblivious of the fact that a law like this has been passed. So they're a long way away from so we'll probably have a situation where one of the companies, and the example I was talking about, the way it is being implemented. So there are actually 3 entities within a corporate structure. One is compliance, and compliance is usually self-governance. So that's why you have a lot of ISO standards and everything, which the company puts in mostly from a contractual obligation to somebody it's getting into a trading agreement with. The other is your finance, which is only looking at how to minimize the cost of these things, because compliance and legal both are cost centers.
Correct.
We really don't end up being the increasing the bottom line. So if you look at it from that aspect, this is going to be a compliance burden. Now, it is a very hard task for them to move this from a compliance from a self-regulation to compliance to a law. That when it moves, that is when they will realize that this is a law which has to be implemented. and the compliance will then be handed over to the legal. And when it comes to legal, that means we have an obligation of keeping our CEO out of jail. Till that time, this is just a burden on the company, and this is the kind of hassle or I'm forgetting IT, because ultimately the bedrock is IT. So right now there are 3 or 4 players who are juggling this, and till the time we don't get people to appreciate that the fines are in the tune of 250 crores plus any punitive damages to the people aggrieved. Correct. Because both of these can come to play. Till that message is not sent out properly, this juggling act inside will keep happening. And the ownership is always going to be a cost center, so funds and budgets will not be allocated. And we will have, so everybody is right now assuming, just like GDPR gave 2 to 3 years for getting up to speed and complying, everybody is expecting that will happen in India. But I'm pretty sure that won't, because most of your trading organizations do not expect you to sit tight for 3 years till you comply. Your IT business is going to get affected by that.
So you sort of really put your neck out there insofar as where you believe this thing stands. So I was looking at the role of significant data fiduciaries under the DPDP Act. So there are companies that collect much more larger volumes of data as opposed to smaller companies. They are sort of equivalent to the significant social media intermediaries under the Digital Media Ethics Code. So there is greater obligations on them under the law. They've got to appoint a nodal officer inside, to whom all grievances would lie, and then based on that decision, it goes to the Data Protection Board and then to TDSAT, I think, right? Yeah, correct. Yeah. I'm not sure why they did that. Perhaps they just wanted to make it easy. So I'm now going to go back to you, Pooja, actually, to answer the unanswered question. He very unequivocally put it that it's a cost center. It's something that is a burden on the company. Finance doesn't want to spend money, and therefore will large companies put their heart and soul into it? I'm going to put you on the spot and ask you to give a very candid answer based on your prior work experience.
So, Vishnu, it is quite evident from whatever we have seen over the years that when something becomes mandatory to be complied with as per law, obviously nobody has a choice. Right. Till then, we can say that we are still trying to put the house in order, still trying to figure out where are the pain points and working around it, getting an audit done. So ultimately compliance will have to be done. We only have a window till maybe the rules don't come in, and whatever time the rules permit the industries to kind of put things in order. That is the only window we have. Okay. It will not be that anybody can get away with it. Right. But then the fact is that, like Gurjot said, that different departments are working in isolation. So finance doesn't know what marketing is doing, marketing doesn't know what sales is doing. Nobody wants to, even if they know internally, officially, they will maintain that they are not aware. So you buy a car, suppose, and 1 week later, because your details have now got into their system, you will get a call that you can get a club membership. And some of the telecallers are smart enough to even say that you bought the car and that is why we are giving you this offer, without realizing that this is not what the purpose of giving that information was. Similarly, when you are, buying some commodity, medicine, suppose you are buying, next time the pharmacy will call you back or send you a message or a WhatsApp saying that on your regular medicine purchase, we are going to give you 25% discount, and you happily lap it up without realizing that your profiling is being done, that this is the kind of medicine you buy on a regular basis. Very, very relevant. So do you want to really be identified and marked like that? Yeah. Whereas you may not be using it personally, it may be for somebody else in the family. There are other aspects also, like I am not a smoker, suppose I am not a smoker at home, but at office I do smoke. At home people don't know. Now there's nothing moral, immoral, but if that data reaches home, that SMS reaches home, that my phone is lying there and it says I will get 25% off on the next carton I buy, it will create havoc at home. Correct. Because not only just because of that reason, I may be from a financially poor background and that indulgence may be frowned upon. Yeah. That here you are telling us I can't buy this, buy that, and you are busy smoking up the money.
Well, not to mention the the ill effects of actually smoking more cigarettes, because there's a discount on offer. It's like saying when you walk into duty free today, So if you have 1 plus 1 free, then you know it's also
Exactly.
1 plus 1 free on the stomach.
Advertising is not allowed, and here you are giving an offer, luring the
Correct.
customer to come back to just the same brand. So I mean, there are a lot of aspects which come in which people don't realize.
Correct.
And if I, as an informed customer, once this act comes into effect, want to sue them, I can easily sue them. That this is the misuse of data that is happening, and this is the reputational loss that has happened, and this is the other damage that has happened to me.
So there's a very strong undercurrent of ethical and
Absolutely.
sensitive
I mean,
ethics in this. Yeah.
Once privacy issues come in,
Correct.
so it is not about whether it is moral or immoral. It
Correct.
is a privacy issue,
Correct.
which you have violated simply because you chose to send these mass messages. Right?
Correct. Correct.
So those are aspects which have to be understood first. There is no sensitivity, by and large, in the Indian industry, in the Indian mindset about honoring the privacy of a person. Per se, they feel once you've got hold of data, use it to the maximum.
Correct.
To make
Exploit
as
it to
many
the
kind
hilt,
of marketing offers as possible. That mindset has to be seen. Where did you get that data? That question. This Bajaj Finance.
Correct.
Everyone was sick and tired of the number of calls.
Absolutely.
I
think there is complete, unanimous agreement on that, right?
But I have noticed, I don't know how many of you have noticed, ever since this DPDP Act has come, I have at least stopped receiving so many calls from Bajaj Finance on a daily basis.
Do you know, I get calls from random numbers saying we need to come and service your RO water purifier. I told consecutive people that I don't have a RO water purifier. So one lady asked me, so what do you do? I said I drink water from a pond. She didn't believe me. I was joking, but I actually don't have an RO purifier at home. So it's not that so the next answer was that in Gurgaon, where I live, there are 108 ponds, and every day I go to a different pond to collect drinking water, but it didn't come to that, luckily.
Maybe after this, you'll get call from RO companies.
See, I mean, this listens to everything. But so that's a very wonderful insight. You have a little sensitive, ethical, mental undercurrent here, which is very, very important. And on that note, again, being mindful of our time, I'm going to go to Vishwajanani again, because there's a very, very important and a very futuristic kind of projections here that patient data is going to assume immense significance in the times to come, especially when it concerns data privacy, because it's not just discounts on medicine. It's not just, okay, you buy 4 packs of amoxicillin, we're going to give you 4 packs more. I mean, do you want to really consume double the amount of antibiotics? No. So companies are actually looking at devices to understand patients better, and devices capture a lot of information. Devices connected to the devices capture a lot of information, and this information is going to spread, and I'm using the word not rapidly but rapidly, amongst the entire pharmaceutical industry. And therefore, what does the industry do, or what do you think the industry should do to ensure that there is some sanctity to the information and we don't create the kind of anxiety and fear amongst patients simply because tons of data is floating around and a lot of information is provided to the patients to make not very discerning choices on treatments and drugs? Sorry if I put you on the spot with a very pointed question.
No, I think I would limit myself as a researcher, as an R&D person, because touching upon the industry needs would be too long, I think, and too far-fetched for me.
No, that's fine, that's fine.
So, yeah, so as a researcher, when I look at the healthcare, there are 2 aspects to it. One is the R&D part of it, that is where you nowadays I think even the industries are indulging in e-lab notebooks, and there's a lot of data that is being captured, and we don't know where it is being captured, largely in the cloud, but who's accessing that data, we have no clue, and how much of the data is being transmitted to the outside world is also no clue. I think these impact assessments become a necessity to monitor the usage of such data, where it is stored, how it is being used, and how long it is being retained. That is one part of it. The second part is the clinical trials. There's a lot of information that is captured, including the patient data. Yet again, much of this information is captured in the cloud. And especially during the COVID times, I had seen, when you do a clinical trial, there is a daily monitoring of the patients. Traditionally, the notebook, there's a patient diary system that was being followed. Now it is all the e-platform. There are so many apps that have been developed. So every patient is required to capture their everyday data into that particular app. Okay, and what's the security? I see Airtel capturing all my UPI, all my bank accounts are detailed on the Airtel application, and I was really shocked to know that they know all the accounts that I have, and all.
They probably know more.
More. Okay, and where are they storing this information? How is it being transmitted? So if I look at that, okay, I mean, perhaps feel a little safe that the bank data is largely perhaps encrypted in terms of the nuances, okay. But what about the patient data? We don't even know the safety and security of the apps that are being created by every third party that believes it is an IT industry. And when this information goes into the public domain and or is in the wrong hands, and especially considering the AI that we are all talking about, I'm just a little worried.
So on that note, I'm actually drawn back to what I spoke about initially, that one of the central tenets of data privacy is informed consent. So I think informed consent must be coupled with very responsible handling of data by companies, and all the speakers spoke about the relevance of impact assessments. The aspect of impact assessment is actually not new. In trademark law, we've had the concept of naked licensing for many, many decades. And the central tenet of naked licensing is constant observation so that there is detection of infringement and remedial action. So you might want to license your brand to someone, but if you sleep on it and for 10 years the quality control goes for a toss, then it's very difficult actually to go to a court and seek relief for poor quality of goods or services that are provided under the licensed trademark. In the same way, I think the key aspect about impact assessments is regular assessment, regular monitoring, and regular remedial action. And I think it is this constant vigilance that will actually ensure that the sanctity of the law and the foundation that the law has aimed to provide us will continue in the years to come. So we must all use this takeaway of responsible handling of data and periodical impact assessments as a little bedrock to see where we are headed with the law in the times to come. And of course, we will all see how the courts implemented, how the government brings various rules into force in the times to come. My guess is they will likely take sets of rules and bring them into force on different dates. And therefore, you're willy-nilly looking at, as Pooja said, a little sunrise period now, where it's time for companies, it's time for stakeholders, it's time for all of us as well, who are all stakeholders in this, to sort of get our act together before things start coming into force, and then we able to have a better understanding of where we stand on day zero. Correct? Right. All right. So on that note, I'd like to thank all my co-panelists for an engaging session. I hope you found the session as engaging as I did, and they did as well. So on that note, I'll hand the dais back to Purvi, who can take over and introduce the next set of speakers. Thank you so much. Just a second. Thank you all. Thank you.
Thank you, Mr. Mishru Mohan, for making the panel discussions both engaging and informative, leaving a lasting impact on all the participants. We also thank all the panelists for their valuable insights. Now we will be moving ahead with our panel discussions. The next discussions would be on emerging technologies and IP challenges, with a special focus on artificial intelligence and blockchain technology, and how we can have an industry academia collaboration involving both blockchain and AI technology. For this session, I would like to invite moderator of this session, Dr. Ajay Garg. He is Director, Digital Tech and Law, Anand & Anand. Okay. He might be joining in few minutes. Dr. Hemang Shah, India and Engineering Lead Director, Qualcomm Technology Licensing, Qualcomm. Mr. Pankaj Soni, partner and friend Sagar. A round of applause for all the learned speakers. Ms. Shilpi Jha, a senior commercial specialist and IP policy advisor, South Asia, US PTO, Office of South Asia. Ms. Pragya Chaturvedi, senior intellectual property advisor, British High Commission, New Delhi. She will also be joining in few minutes. Dr. Sandeep Chatterjee, Senior Director, Ministry of Electronics and Information Technology. He will also be joining us in few minutes. We will also have virtual presence of Dr. B.K. Sahu, his HOD Technology Innovation and Intellectual Property Facilitation, NRDC. To save on time, let me read out the profile of Dr. Hemang Shah. Dr. Hemang Shah is the Director of Engineering with Qualcomm Technology Licensing in India. Currently, he leads their engineering engagements in India, including the Qualcomm Design in India program. Through this program, they have incubated and mentored 130 plus startups working on innovative products for sectors including healthcare, smart cities, agri-tech, robotics, and more. He also serves as an IP mentor for startups, guiding them for their IP strategy. Dr. Shah has led IP portfolio projects for development, commercialization, and litigation objectives. He enjoys the intersection of technology domains and has R&D experience of projects spanning high-tech and nanotechnology. He is also co-chair of ASSOCHAM National IPR Council. We welcome you, sir. His CV is quite big. Dr. Shah also holds a doctorate in electrical engineering from Drexel University. He is a certified design thinking expert and enjoys sharing insights on innovation. He has 10 plus patents granted and pending, and apart from several peer-reviewed publications. We welcome you, sir. So we have Dr. Ajay Garg with us now. To brief our audience, he is an electrical engineer with doctoral degree from IIT Kanpur. Dr. Garg is a seasoned technocrat with 25 plus years of experience and a proven track record for professional excellence. He is known for his target-driven approach and pushing the boundaries of innovation. Dr. Garg devised and led from the front myriad mission-critical digital transformation initiatives at MeitY. Apart from being a key contributor to various technology-oriented and trade and policy-related strategic forums of Government of India, which includes AI, data, cybersecurity technology, regulations, and emerging tech. Currently, Dr. Garg is heading the digital tech and law group at Anand & Anand, where the firm is in the process of evolving its expertise on legal and advisory aspects on emerging tech, including AI, considering the fact that it will be center to future innovation economic growth. He had strategically negotiated and managed various agreements, trade issues, and MOUs with 50 plus countries amid lean resources and outcome complexities. Till recently, as a senior director in MeitY, Government of India, he was tasked with the responsibilities of key divisions including startup, innovation and IPR, international cooperation and ITES industries, promotion among others. During his stint, he had formulated and implemented some of the groundbreaking initiatives such as MeitY Startup Hub, National IT Policy and National Policy on Software Products. He will be moderating the session. We already know Mr. Pankaj Soni. He was also there in the inaugural session, so I'll just read out the profile of Ms. Shilpi Jha. Ms. Shilpi Jha is a senior legal counsel, IP Council, South Asia, in the Office of Patent and Trademark, US Embassy in Delhi. She is lead IP specialist responsible for monitoring, devising, analyzing, and reporting on intellectual property matters related to India and South Asian countries. She has experience of over 18 years in legal practice, business development, and public policy. Before joining the US PTO, she worked at CII. She was responsible for framing, drafting policy papers, inputs, and the industry face to the government of IPR related matters. Yeah, round of applause for our speakers, Ms. Shilpi Jain and Dr. Sandeep Chatterjee. Sorry, Ms. Pragya. Okay. Yeah. We have our guest of honor with us, Honorable Justice C. Harishankar, Judge of High Court, Delhi. Thank you, sir, for coming. She has been the recipient of various awards, including the USPTO Directors Award, Superior Honor Award, and has been recognized as WIPF Powerful Women in IP India 2021 for contributions in creating, protecting, and securing intellectual property rights. We welcome you, ma'am. We would like to also introduce to you Ms. Pragya Chaturvedi. Ms. Pragya is UK IPO's intellectual property attached for India and South Asia. In India, Pragya works in close collaboration with Government of India to deliver the work plan between the Intellectual Property Office and Office of the Controller General of Patents, Design and Trademarks, which involves engaging with various stakeholders on IP awareness and policy issues. This follows the MOU between the Department of Promotion of Industry and Internal Trade, India, and the IPO. The offices have shared the aim of strengthening the IP ecosystem and enhancing ease of doing business. As an integral part of the DBT trade team in the British High Commission, Pragya also works closely on the UK-India FTA negotiation. She also advises UK business on local IP issues in India. She also engages and advises regional HMG colleagues to deliver projects in line with IPO's objective. Thank you for joining, ma'am. Dr. B.K. Sahu would be joining us virtually. We have with us Dr. Sandeep Chatterjee. He is a leading global policymaker and experienced techno administrator with over 25 years of experience in translating research outcomes into commercial viability and disruptive policy making. Dr. Chatterjee has an avid interest in bridging the gap between R&D outcomes and needs of emerging businesses and local industries. Currently, he is responsible for strategizing India R&D in materials, photonics, IoT sensors, additive manufacturing, and the successful commercialization. He is responsible for creating a vibrant entrepreneurial ecosystem, engaging industrial and state government stakeholders. He has established 12 plus centers of excellence in emerging technologies. He is a visionary leader who had consistently delivered on strategic innovation, international policy negotiation, and advocacy. We welcome you, sir. And we will be also having Professor, Dr. B.K. Sahu with us virtually. He is also a technology transfer, intellectual property, and innovation management professional in academic training and profession with more than 20 years of academic research and professional experience in IP management, technology transfer, and innovation management. He is MPhil and PhD on IP and innovation management from JNU New Delhi. He is also an innovation management professional from Copenhagen Business School, Denmark, and he is also recipient of many national awards, like twice he was awarded with the Best Technology Innovation Support Center in 2020 and 23. He specializes in strategic technology innovation management, technology transfer, and commercialization, bringing inventions on the market, business, intelligence, science, technology and innovation, and public policy with expertise in IP, due diligence, technology scouting, IP portfolio management, mentoring startups, and so on. We welcome you, sir. You have a very rich profile. So, not taking much of our time, over to you, Dr. Garg.
Good evening. We welcome Justice Harishankar ji here in this hour. We are honored to be here. Thank you, IP, Ericsson, and all for organizing this very intriguing sessions every year. I have been part of this for last 6-7 years, and I am privileged to be here again. I have got a very rich panel, crossing borders and crossing innovation paradigms, discussing on a very important issue, which is around the emerging tech and IP. The tech has always been emerging since the evolution of humankind, and there is nothing great about a word called emerging tech. But today in 2023, when we are sitting here and talking about emerging tech, we are talking about a revolution in the technology domain where the traditional intellectual property elements, which were industrial applications, creativity, and brands, now have an additional element to it. And the earlier session was discussing around how do you protect data, specifically personal data. But now data has become a driver for economic growth. And it has become very important in the emerging tech that how do you actually monetize data, and in a way, how do you provide an atmosphere for protection of data as a tangible good. Because the copyright law, which was traditionally has been used for protecting data, is insufficient in a form that first, in most of the geographies, data in the form of structured data or data sets are protectable, copyrightable materials. Unstructured or raw data is never, and which is very important in the emerging tech. And the second important issue around data is that that now, because of a borderless nature of the technology, data travels around seamlessly around across borders. And how do you actually provide them a mechanism of an international means to protect and not being misappropriated by, right? The third very important thing is around the ethics, which this technology is now touching upon. When the nuclear technologies came in the early 20th century, nuclear technologies which were actually impacting the very existence of mankind were not patentable subject matters, sir. The same is a scenario now with AI, where AI and technologies which have a potential to actually impact on the very existence of mankind. The technology has evolved to a level, we hear about the deep fakes and dark patterns, which are the early stage of this, but AI has a potential even to control the most lethal of the weapons that mankind has produced. And how do you actually stop technology controlling the destructive power is very important. So this is why when we talk about the emerging tech and IP in the present domain, it becomes important. And I'm very happy and privileged to have with me a very important panel. And let me start as usual. You start with either you start with the government or you try to end with the government to find a solution. So what will you prefer, Sandeep?
Thank you, Dr. Garg.
So my question is very simple, Sandeep, that you are looking at a gamut of laws or regulations that are evolving in the present era, and digital, I think, has become the most painful subject matter that the judiciary has been dealing today. So how are you actually working around in India to reduce the pain of the judiciary and in turn create a better tangible environment where economics and ethics flow together?
Thank you, Dr. Garg. If you see the formation of our ministry, and till date we are now discussing about the emerging tech. So these are technology related matters our ministry is handling. Mostly we are actually the promoters of these industries. And we have seen how IT industry has grew for last 4 decades. And now for last 7-8 years, we have actually nurturing the emerging technology. And our Digital India program, if you see, it has contributed a lot. If you see the 132 crores, other enabling in the masses, and also 14 crores of internet users, and also last 26 to 2016, the data affordability to the masses has enhanced the different type of businesses over the internet. So the internet, if you are talking about the IT Act, it was enacted in 2000, is already dated. So ministry is understanding the issue. There is a need to come out with a different enabling mechanisms to deal with emerging technology. But we are not actually interested to make a very stringent regulation so that the startup growth and other activity in our country should be stopped. So there is a nuanced view has been taken in our ministry. You must have seen there was a initial version of the data protection rule in 2018, but we have changed a entire principles and entire rules, so that now we are not talking about data should be localized. So we have a provision of data can go to the any geography depending on our relation with those countries. And also you must have seen that we are given a lot of provisions for small SMEs, MSME startup to use that data as a fiduciary, and we have changed that criminal provision to just financial obligation. So those things are showing that we are still proactive to boost our industry. We should grow and learn, and then we can amend whatever the challenges are coming into the thing. As Dr. Garg mentioned, deep fake, because AI we are using for many important development work. So we cannot just stop its growth. But there are rogue elements, they are using that AI for some of the issues. Of course, if you see our IT intermediaries rule notified in 6th April of 2023, enough provision is there to contain those, because the due diligence are there to the intermediaries, and they should do the due diligence of 3.1b. There are 11 different items. And we are today morning also there was a meeting with MOS. So we are saying that whatever the provision is still there, not being utilized or misrepresented. Like if you are having a complaint, so the grievance officer should register that and giving a token number. So they are doing that grievances in-app. It was not the mentioned in our rules, but they have made it like that. So we are clarifying it. We are issuing the notices and also the advisories, so that whoever is aggrieved, they should report it, and you decide whether it is a content related complaint or the service related complaint, and accordingly you issue a token number, so that the grievance appellate committee we set up should get it directly access to that complaint. So those things are, if you see the entire 3.1b, there are some repercussion in IPC as well, CRPC as well. So whatever is unlawful in physical world, so the provision is there that is unlawful in our cyber world also. So legal framework actually giving an enabling mechanism to grow our industry, but we should see there should be a check balance, so that we should use this. And of course we are always listening to different stakeholders where we require more stringent provision. We are working on that. Especially on deepfake, we are started working on that, how it could be make more responsible for the content developer. Because for AI also, now another thing I should mention, Dr. Garg, we are already in a advanced stage of coming up with a new version of the IT Act, Digital India Act. Our Ministry of States has been taking a lot of Digital India dialogue in various parts of the country, and we are in a final stage. This will be actually since the election is coming, I may not see that it will be passed before the election, but we are in a final stage. So we have done due diligence so that entire rule of IT Act should be replaced based on the present context of the emerging technology. So, and also if you see the IT Act, lot of technological jargons has been mentioned. So we will be following the principle of DPDP Act we have enacted in August 2023. So it will be very simple. It will be, understandable to the commoners, but all other things, provisos and all come to the in a rule stage. So in that way, we are in final stage. So we are, I should say, government is knowing that what are the need now for the country and for growing to the next level of economic growth, because already we are aspiring for $10 trillion economy, and we understand that $2 to $3 trillion will be for the digital technology.
Yeah.
So that is what Dr.
Yeah. So what I have found is that the proactive nature of the Ministry of Electronics and IT, which of recent has come to the headlines, whereas it used to be on the page 8 and 9 of the newspapers. That's a change. But the point, Sandeep, what I'll just conclude around is the technology, the ease and the size of the problem is so big that the law and regulation also needs the technology itself as an intervening parameter to actually kill it. So let me, Pragya has got a flight to take, so I'll put on. Pragya, UK has come out of the EU, so the EU regulations no more are so applicable. The secondly, your Prime Minister himself had a very big conclave around the emerging tech and AI recently, and where India also participated actively, and you are trying to renegotiate the trade negotiations with most of the countries. With what I understand, with my limited knowledge around that subject, is that the tech and IP forms the core of those tech trade negotiations. So can you enlighten the audience that how is it different from the way EU is thinking about the subject?
Thank you, Dr. Garg, and also thank you IPTSE for organizing this session. It's a pleasure to be here. So Dr. Garg, about your question about what the UK is now doing on emerging technologies and IP. So the Prime Minister himself has announced, emerging technology is one of the priorities for the UK. As you mentioned, the Prime Minister also recently spoke about the draft AI regulation strategy. It's still in its draft form, but I'll come to the details of it later. There's the AI summit happening later this month. Our Under Secretary for AI and IP is also joining, so UK is represented in those discussions also. In terms of emerging technologies, there are several strands of work ongoing. We don't have definitive guidance yet because we are still at consultative stages. We are working collaboratively with stakeholders from all different areas to take their views and then formulate a definitive strategy. But within all these strands of work, innovation is at the very heart of it. So the government's priority is to have any strategy, any draft regulation to be very pro-innovation and not something that stifles innovation in this space. So one overarching framework that the UK is coming up is the draft Science, Innovation and Technology Framework. And the IP office now sits under the Department of Science, Innovation and Technology, so that signals how important IP is in driving innovation and growth in this sector forward. So the framework itself is an overarching framework to signify UK's commitment towards promoting growth and innovation in emerging technologies. We have identified 5 critical technologies as part of this framework that includes AI, quantum technologies, semiconductors, engineering, biology, and future telecommunications, including 6G technologies. And there has been a lot of initial work on these emerging technologies, including publication of draft strategies in these different fields, including wireless infrastructure, quantum technology, engineering, biology, and then there's also a plan to develop a strategy for each of these critical technologies, so we are able to maximize the advantages that the country is getting from these technologies. Then, as part of the framework, there are other pillars that are supporting the development of the overall strategy on technology, and that includes mapping the existing talent and skills in this sector, and then looking at how we can promote further development of talent and skills, including research and capacity building in this sector. Then setting aside some fixed amount of government spending to promote critical innovation in these emerging technologies, making sure there is access to physical and digital infrastructure that promotes growth in critical technologies. The regulatory framework, including the IP framework, is conducive to development of emerging technologies. It doesn't hinder or inhibit it in any way. Then another key component is making sure that the public sector, the government is innovative, and that includes promoting participation from the STEM sector in, and having more people in the government from the STEM sector. In fact, the IPO has this scheme for women from the STEM sector to be part of the IPO's workforce. And also another part is ensuring there is financing available for innovative businesses, including businesses which are focusing on critical technologies that can solve some of the global challenges. Another part of this framework is the UK government's innovation strategy. So a couple of years back, the government launched its nationwide innovation strategy that again has several components that make sure that UK is one of the most innovative places. People who want to innovate are properly supported. Businesses have the infrastructure, innovative businesses have the infrastructure to grow and progress. And we invest adequately in research and development in emerging technologies. So there was a record £22 billion set aside just to invest in the research and development and innovation framework. So this is just an overall view of the framework and the initial work that is ongoing. Then there is the AI strategy that sets the overall approach that the UK government is going to take in terms of AI and the regulation of AI. Being pro-innovation is of course one part of it. Another is the adaptability, because it has to be future-proof with the speed at which AI is developing. So it has to take into account all the developments that are taking place in the field. It has to be clear. Businesses have to be clear about who is making the rules, how to enforce them, how to ensure compliance. It has to be transparent. And it also has to take into account all the risks that AI or other emerging technologies can present, and then looking at adequate frameworks to address and mitigate those risks. And one important part is that the UK government is not applying any rules or any risk factors to AI or any emerging technology as a whole. So the plan is to have an overarching body to look after regulation of AI, and then have sector-specific regulators to look at the application of these technologies in each sector, and then decide how to move forward. And as part of it, the UK IPO has also undertaken some rounds of consultations on AI and IP frameworks, and how IP ties into protection of these AI-driven technologies or creations. So we have had 2 rounds of consultations till now. We have received several responses from different stakeholders. And there were 3 factors under consideration. One is exceptions for text and data mining, one was copyright protection for AI assisted creations, and one was protection of patents assisted by AI. So 2 rounds of consultations are over, but we still are not at that stage because of the rapidly evolving nature of the technology and several stakeholder comments that we have received. We are not at that stage where we can announce or where we can decide where IP sits within AI and whether or not AI-driven innovation or creations can be protected, but we are looking at a collaborative approach with different economies, different countries who are looking at AI and IP policy. So we'll be working in consultation with different stakeholders, both in the UK and then international partners, while this framework evolves and before we can arrive on something definitive and final that can form part of the overall UK government policy. Thank you, Dr.
Bhagya. So very interesting that UK now trying to face the challenges which the Brexit has posed to them, have actually embraced upon technology to be the savior. So before I move to the practitioners, let me finish off with the government part. Shilpi, you represent USPTO here. So US has always been the leader in innovation and protection and giving giving some sort of a tangibility and monopolistic value to innovation. The emerging tech has actually thrown a number of challenges which are reflected in the number of case laws that are there in US or ongoing cases, which is maximum in US. So how is USPTO increasing capacity and the regulatory framework around emerging tech? Can you just give us a brief? I know it's a whole day session in itself.
No, thank you for that question. So before I start, I just want to thank ASSOCHAM and IPTSE for inviting us for this panel discussion. And so as you rightly pointed out, I think two of our panelists has already mentioned that because AI and the emerging technology, AI's impact on emerging technology is so important that because of that, recently I'm sure all those who have interest in AI and emerging technology must be following it, that President Biden has signed a executive order on how to manage AI with different departments and all. So it's an executive order of around 111 pages around, and it is majorly to evaluate and see how to safeguard the impact of AI on emerging technology, because as we have rightly understood that we cannot stop AIs in the emerging technologies, because that's not only help us to generate more, but it also help us to speed up in a large scale. So looking at the time requirement, Biden government signed this executive order, but before that, all of the agencies in US has been doing a lot in emerging technology. The only purpose of this particular executive order was that because there was various judgment was taking place, which some judgment mentioned that AI generated copyrighted product or IP is not owned by the AI. There has to be some new rules and regulations. So with these backgrounds, this executive order was signed, and the whole purpose was to see that what best way is to protect, at the same time see that AI, which is going to be implementing and facilitating, creating more innovation and more IP generation, how to safeguard that, keeping in mind the owner of the innovators, the consumer who is going to be impacted, at the same time those who are going to be using it for their own purpose. So this what this Biden executive order has done is that it has given the different domain aspect of monitoring and practicing IP and coming out with different kind of rules and regulation to different department. For example, it has entitled 4 major department: NIST, USPTO, BIS, and National Information and Telecommunication Administration, to look into different aspects. For example, USPTO has been assigned to see how emerging technology and AI generated IP innovation can interplay between innovation and IP at the same time. Similarly, for NIST, it has given them a responsibility to come out with framework, rules and guidelines to see what basic standard any technology should come out with, because if it is going to rule the economy, it needs some kind of guidelines and formulation to see how well it is, it meets the purpose of what it is getting into. And for business BIS, it is for the standards, what standards every technology should follow. And for that, every agency which has been given this responsibility, what they are doing is that while they are trying to formulate guidelines and regulation, they are doing a lot of stakeholder discussion. For example, USP2, I think since 2020, USP2 has been using AI technology to do a lot of research and coming out with compilation on trademark and patent. So these kind of things has been in practice in US, but this Biden executive order is going to make it more formalized and see what is the best way to make it secure and consumer is protected by AI and used technology generated product.
Thank you, Shilpi. I think the consumer protection is very important, and the recent consumer dark pattern consumer protection regulations is a very important step in this. If I can go over to, no, I usually call you Hemant, so you are now Dr. Shah, so I have to be formal. So Qualcomm has always been a leader in IP and innovation, and what I understand is that you have now, to maintain that leadership, you are also partnering with a lot of startups in India and globally. So can you give us give us a perspective on how do you manage IP in this partnership model with a large tech partnering with young startups?
Thank you, Dr. Garg. Thank you, IPTSE team, for bringing us all together. This is a wonderful panel, and truly, one where we have a lot of learning, that we're going through, various perspectives coming together. To just give you a brief about how we are supporting startups, I think to go with what Dr. Chatterjee had shared earlier, which is the Digital India mission, when it was launched in 2015. I think that was the same time when we had started our startup program. And till date, we have partnered and worked with 130 plus startups in India. This is first time experience that we have. These broadly cover the deep tech verticals. When I say deep tech, in terms of applications, they cover medical devices, they cover drones, they cover e-bikes, like I think there was so pretty much anything and everything which requires connected technology. One of the main things that we have always kept at the forefront is to keep an eye on what the country's needs are and what the startups are solving. So these startups they start with solving a local problem around them. And by the way, for that we have to thank the Startup India and the MeitY departments, because that's how we get connected to them in the first place. I'll just give you a couple of examples of the kind of problems which are, and in line with our panel discussion today. We have Product Dev Edge, which is led by Simi, and what they are doing is they are solving for a problem for the cosmetic industry. We have a large cosmetics industry in the country. A lot of FMCG products exist, but it takes a long time to crack a good formulation which works for them. So what they are doing is their idea is to get the different recipes, the different ingredients, and they will generate possible formulations which are bringing the cost significantly down to market. We have companies which are making underwater drones and over-the-surface drones. Now we all know about aerial drones. Now aerial drones are meant for, like, say, over-the-air delivery, over-the-air monitoring. But India has a lot of waterways, a lot of canals, a lot of rivers, and they need a lot of surveying. Like, you can have bridges which are running over the water and they are corroding from inside. You have various waterways which are being used for transport. Now, how do you get accurate map information from them? So we have these companies which are surveying these using connected devices. Now, the question you may ask is, what role does AI play over there in the first place, and how can they innovate, on that front? A lot of these applications, initially they may start off as pure cloud applications, where they collect a lot of data and this data is sent over the cloud interface to the servers where the compute happens, and then the analysis is finally fed back into the device again. But what we see with time is that it's a more of an edge plus cloud type of an application, because they want to do all that processing as much as possible on the device itself. This gets them better data, it gets them faster decision making real time. The way we partner with them is we first try to understand what their use case is. We try to bring their path to production faster by providing them with development kits. We provide them mentorship on different aspects. In terms of IP rights, my feedback to these startups is that you have spotted a very good problem and you have come up with an interesting solution. This is the edge that you've created. And if you don't protect that edge, you will soon have others that will come and try to take that advantage away from you. Protecting your IP rights is the only way that you can stay relevant in the long-term game, because a startup is on a journey of multiple years. So having a strong IP portfolio gives them unique advantages from a protection perspective. We are also seeing IP-based exits. One of our startups that had developed radar-based imaging technologies was acquired last year because of the strong IP portfolio that they had created. So it involves us giving guidance to them. And actually a room like this would be perfect for the startups. I mean, look at the spectrum we have. We have the IPTSE award winners, which are the budding IP professionals of tomorrow. And the rest of the people on this panel and in this room are the seasoned IP experts. Startups don't get this kind of face time with a room like this. So we created a program called L2 Pro. This is in partnership with DPIIT and with NLU Delhi. So this acts like a reference guide, which is IP material for them on how they can spot innovation opportunities, how they can find patent facilitators, how they can take care of various aspects such as contracts, restrictive covenants in a easy to digest format. So it's meant for CTOs, and we have one of the co-authors of the program over here, Pragya, in her past role, like she contributed extensively towards this program. So I guess in summary what we can say is that the way we ensure that these startups are successful is by teaching what we practice as a company best, which is focus on deep tech, focus on a systems mindset, which is you're not just solving for yourself, you're solving for end-to-end, and ensuring that IP is a core aspect of your business strategy. So I'll pause here and see, happy to chime in further with examples as required.
I think before Pankaj, I'll excuse you, take your excuse to actually put a question, because Dr. Sahu is in midst of a deadly cyclone that is there in Vizag right now. And I think before we lose him, we take some very important insights from him. Dr. Sahu, are you able to hear me?
Thank you, Dr. Garg, for giving this opportunity, and good evening all. Good evening all the panelists. It's my honor and privilege to be part of this program, and the program is close to my heart and my profession and my activities, what we do, NRDC as a national organization in the country. Academia industry collaboration, emerging technology and challenge of intellectual property right. So yes, when we are talking about academia industry collaboration, whether our academia is serious on that part when we are talking about IP. Because why we are talking about academia and industry collaboration, the most important is research commercialization and also economic growth, center of excellence and innovation, and also global competition, because that is the need of our for country to achieve the global innovation index. There is a paradigm shift of global innovation index. We are doing our best, but India having, I think, more than 900 universities across the country, and that too I will talk about academia, and we have more than 11,000 engineering colleges. But at the same time, we must have to emphasize the ignorance of intellectual property in academia. Yes, there is a seriousness, there is a change of mindset, but when we are talking about intellectual property, that too on the emerging technology, the technology related to artificial intelligence, blockchain, what we are talking about today, we must understand what are the benefit sharing between academia and industry and how serious academia to mitigate the challenge of the industry today. Yes, there is a great momentum of all the form of mission mode program, Make in India, Startup India, Digital India, Skill India, Innovative India. Now we are talking about self-reliant India. So when we are talking about emerging technology, that too on artificial intelligence and also blockchain, we must have to redefine the Patent Act. Section 2P of Indian Patent Act, Section 2T of Indian Patent Act. Because when we are talking about AI generation, innovation and work, who should own and what are the challenges, and we have to come out with a solution for that, and policy is most important for that, and that we need to address. And also we must have to understand the blockchain, because it is a continuous proof of ownership we are talking about, and the technology has a great impact. And there are issues, particularly the privacy, jurisdiction, compatibility, and we need to understand the academic perspective as far as the academia industry collaboration on emerging technology, that too on sponsored research, collaborating research, granting-led research, and also contract research. So we must not confine how the intellectual property to a particular sector of technology. We have to see holistically when we talk about artificial intelligence, blockchain, 3D, and many more technology are coming, and that is a continuous process of innovation. But certainly I will touch upon the challenge. Particularly we must have to understand the section 2D of Indian Copyright Act, particularly the author. When there is a innovation and invention or something will come out through ChatGPT, who will be the ownership? What kind of ownership we will give, and how we define this Copyright Act of 1957 under Section 2D. So these are the challenge, these are the policy. Although I am not a legal professional, but as a IP professional in doing technology transfer and supporting intellectual property, and I'm so happy that panelists are known to us in our many activities. We have collaborated, we have co-created the invention, and many of the invention we have taken to the market, and that's the innovation we are celebrating in this Amrit Kal. And because of the time, and also we are badly affected, particularly on the this cyclonic storm, and I am really grateful that you have given me this opportunity, and I am grateful to the chair and also IPTSE and NASCOM for giving this opportunity. But certainly I will request you and urge you, it is a time when we talk about technology and innovation, intellectual property right, there must be a policy changes, and policy changes is taking place, but the deliberation, articulation, and also redefining the policy is need of the hour. Thank you for giving this opportunity. God bless you. Jai Hind. Vande Mataram.
Thank you. Thank you, Dr. Sao. Remain safe and keep helping the innovation community with your with the great support that NRDC has been providing. Pankaj, this you being the last has not been by by intention, but it was by design actually. You've heard the Indian policymaker, the UK perspective, the US perspective, and the industry perspective with regard to the law and regulations, especially in when we limit ourselves to IP, because the regulations have not been, what I understand, have not been there substantive regulations either on IP or in journal or on the emerging tech. There have been no substantive regulations globally till now. There's no global partnership or a agreement on some light touch regulations, which I feel are important if you actually want to take emerging tech forward in a responsible way. So as a legal practitioner, how do you see that, and how are you actually handling the challenges that the digital world or the emerging tech is throwing to the community at large and to the businesses in particular? So how do you see that? How are you actually handling those challenges within the limited scope of present regulations?
Thank you, Dr. Garg. to me, it feels almost like I'm in college and in a group discussion where I've got the benefit of everyone's talk, and I largely have to summarize what everyone's already, they've already answered my questions. I think before I actually share my thoughts, I wanted to take a moment to recognize what India has managed and what we are managing from an Indian judiciary perspective. Your Lordship, Justice Harishankar is here, and then we have example of somebody who's leading from the bench. And I think that that's one thing that as practitioners we look forward to, because like you said, there's not enough regulation, there's limited understanding of application, and so we get a lot of clarification from the courts, and that has helped us in advising clients. Like Hemant said, Hemant is sort of advising clients on startups and telling them, you need to protect your innovation. So go to this lawyer and they'll tell you how to protect it. When they come to us and they say, what's the framework of protection? And I have no answer to them, because we've got a little bit of everything, but there are three fundamental questions. There's underlying the points that everybody has made. There's a question of the eligibility. We have no framework in India on eligibility of these emerging tech, artificial intelligence related inventions. We've got nothing on ownership. I mean, who is the inventor? Who's going to be classified as the inventor? Dr. Sahu presented this section 2P of the Act, which talks about who is the person who is going to be considered as the inventor of an application. We have no clarity on that. And eventually, keeping in mind the ethics and other issues of it, is who is going to be liable? Who has the liability of this if you do something wrong? Who has to take ownership of that wrong once AI moves towards this so-called super intelligence, when it starts doing things on its own? So these are questions that I think fundamentally have to be answered before we as lawyers can actually advise our clients on what to do. These are conversations that as Pragya and as Shilpi has said, that the UK and the US are actually moving in that direction. We don't have an answer to it, but they're actually moving in that direction. And as you said, that we have not had those kind of conversations in India. If those conversations are happening, they are happening in smaller groups, they're happening in isolated groups. I think, especially for AI, India is going to be a country that's going to lead this space. India is going to be a country that's going to be a leader in innovation, is going to be just a global leader in general. Everything is pointing towards India. And for us to be that leader, I think that we need to take a leadership role in this. A very utopian thought process is, let's do it on a global scale. Let's collaborate with the UK, let's collaborate with the USPTO, let's collaborate with the EPO and other organizations and come up with a global framework that works for everyone. But even to get to that point, we have to have a local framework. We have to know what we as a country want to do with these fundamental aspects. And until that happens, we are using the current realm of the patent law. The current realm of the patent law does not even give us proper guidance on how to protect computer-related inventions. We're scratching our head, we're scratching we're having these arguments with the patent office. You're doing this wrong, you need to do it this way. Then we run to court and we tell your lordship, they've done it wrong, you need to fix it for us. And we are scratching our heads there. So let's look at that. Let's have those discussions, let's have those conversations, and we have this room by itself has enough knowledge power to sort of move this forward. And if we have several rooms like this and several people like this, I think it's a matter of time when India finds its place as one of the leaders in this area of technology.
I fully agree with you, Pankaj, that we have the capacity, but what we need is a speed right now. So if we did not had a second Hiroshima or Nagasaki after 80 years, in this 80 years, and we have lived through the whole Cold War, and there is a very there is war going around in the Europe as well as in the Middle East. People keep talking about misappropriating nuclear technologies, but the regulations, global regulations, have been such that we have actually not seen another Hiroshima or Nagasaki, and that's exactly what we need for AI right now, and it's a need of the hour, what I say. So that's my personal belief. But I've been very lucky enough to hear all of you, and it has been a very enlightening panel. And because there are some very important people sitting in this panel, I'll take the liberty of asking the organizers that if we can actually take 2 questions from the audience, that will be useful. Just 2 minutes. And I know we are in between a very important session, and so any questions from the audience? I think no. Yeah, please, sir. Introduce yourself. We don't need it. You are loud enough.
Hi, I'm Ronald. I have this one question about. Hi, am I audible? Yeah. So I have just one question about the ownership of copyrighted materials, as in the generative text and images created by ChatGPT and AI. So I think that is a question that's on everybody's mind. So I'll just refer to 2 cases. So in August, a US court said that the work of art created by AI is not registrable. It cannot be copyrighted. But just 4 days ago, the Internet Court in Beijing in China, they said that it can. So there are 2 differing perspectives in US and China. Same thing, ChatGPT generated images. One says it can be, one says it cannot be. So the differing factor was, I'm sorry it is taking so long. The differing factor is the inputs created by the human being. So one of them say that the inputs created by the human being. So the human that has entered the text into the ChatGPT, that counts as the author. So China court says that. US court says that ultimately it is ChatGPT creating, so you cannot be the author. So which of these, logics or reasons do you agree with? Does the panel agree with? I mean, I know you are not adjudicators, but any insights on that?
Pankaj?
I have a very
Just
simple.
want whom do you agree with?
No, I'm very simple. I agree. When in a few months, when this comes in front of Justice Harishankar, I will agree with what he says.
That's a good thing.
Shilpi?
So, frankly, what I feel is that IP is something which you generate and put in tangible form. And in case of ChatGPT, it's just giving you something. It's not using any idea itself. So IP cannot be owned by it. So in a way, but as a being lawyer also, I would say that it varies from case to case. So we'll have to see what goes input, what is an output, and what kind of idea was given, and what was the tangible form of the object or service, whatever we are doing.
Pragya? Quick one.
So from my perspective, I mean, it's an evolving jurisprudence, and then in different jurisdictions there can be different factors that go into it. From a UK perspective, what we are doing right now, there was a recent case in the UK where a patent was denied to Dabus as an inventor. But what we have decided is that will not judgment is being considered as a standalone judgment, and that will not guide the future AI and IP jurisprudence. So we are considering it as still evolving landscape, and that will form part of our general AI strategy, but that will not the sole guiding factor. So we'll have to see how the jurisprudence evolves on that.
So before the last word from Bharat Sarkar in this panel, I'll say that there are differing ways in which the copyright, my view, the Europe and the UK have a derivative concept in the Copyright Act. The generative aspect of copyrightable subject matter is there in the US law, and the China recent regulations is everything that is that's the state decides around the emerging tech will be the end word. So that's something that is there in my perception. India still needs to have a serious case law around this, and I think as soon as you have something of a challenge to deal with it. Bharat Sarkar. He happens to be my long-term lunch partner, so I take the liberty of this.
Actually, if you see, Ajay, in Digital India Act, we are trying to address this. We're still doing a lot of research. The thought was going around the three different type of player here. If you are posing certain questions, so you are also responsible. Then the developer is an intermediary for us. So he should, those intermediaries should have some responsibility, and the user. So three different categories. So you see how technology, watermarking and other things can say, and some Bard discussing with Google, they're saying that Bard is giving a disclaimer. So it is generated through your certain questions. So if you are posing the different questions, you will get different type of images or answer. So three are different player here. So if you are talking about enabling regulation around it, so you will see different type of punishment and addressing it in Indian rule.
Even Gyurla, we'll give you above the enough.
I'm still learning. So,
so thank you all for bearing with us for this last 1 hour. I think we had a very, very good discussion around a very tricky topic as such, and we hope to keep discussing this before we come up with some serious regulations around. Thank you once more. Yeah, sure, go ahead.
And also I wanted to correct my thank you note. I by mistake thanked ASSOCHAM, just to realize that I have messed it up. It's ASSOCHAM, not NASSCOM. So I want to thank NASSCOM for inviting us for this panel. So November and December is full of conferences. You don't know where you are going at the end.
Thank you.
Thank you. Thank you, Dr. Garg, for your expertise and thoughtful approach, and for having wonderfully moderated the panel discussions that have undoubtedly enriched the experience for everyone. I would also like to thank all our esteemed panelists for the thought-provoking ideas and valuable inputs. I hope you have thoroughly enjoyed the enlightening panel discussions and have unfolded during this incredible conference. As the discussion leaves us with the food for thought and inspiration, we are delighted to commence the award ceremony. Now, moving ahead, we would like to invite, we have with us our guest of honor, Justice C. Harishankar, Judge, High Court of Delhi. We would also like to invite a big round of applause for sir. We would also like to invite on the dais Ms. Gabrielle Moller, Vice President, Patent Development Ericsson. And Ms. Hiteshi Trivedi. In a short while, we will also be having presence of Shri Amitabh Kanji, G20 Sherpa of India. He is yet to come, he is coming, he is joining us in a short while. Yeah. So, for the benefit of our participants, I would just introduce Honorable Justice Shri Harishankar, Judge, High Court of Delhi. Justice Harishankar was born and brought up in Delhi. The son of former Additional Solicitor General M. Chandrasekharan, Justice Harishankar is a third-generation lawyer. He completed his schooling from St. Columbia's School in 1973, whereafter he underwent BSc Honours in Chemistry from the Kirori Mal College and LLB from the Campus Law Center, University of Delhi. He enrolled as an advocate with the Bar Council of Delhi in 1993, since when he was practiced in and appeared before nearly every High Court in India as well as the Supreme Court, apart from the Customs, Excise and Gold Control Appellate Tribunal, the Central Administrative Tribunal, the Appellate Tribunal for Foreign Exchange and other judicial and quasi-judicial tribunals, and educating appellate authorities. His core areas of expertise were indirect taxes, including associate fields such as export and import, foreign exchange, and service law. He was designated as a senior advocate by the High Court of Delhi in August 2014 and was elevated to the bench of Delhi High Court as a permanent judge on 15th May 2017. Since the time of his elevation, Justice Harishankar has sat on nearly every jurisdiction, presiding over a majority of them. He has passed noteworthy judgments in the field of company law, indirect taxes, service law, education, labor law, criminal law, arbitration, code of civil procedure and civil law, and intellectual property, of which he has held the last assignment for nearly 3 years, of which 2 years were spent during the times of COVID. He was known, among other things, for having issued suo motu a slew of directions to be followed in aircraft during the COVID period, which were announced in every flight till last year. He has authored, amongst others, the Decision in Action Committee, Unaided Recognized Private Schools versus Directorate of Education, which held that recognition granted to a school could not be withdrawn in the absence of any allegation of commercialization of education, profiteering, or charging of capitation fees, merely on the ground that the approval of the DOE was not obtained before increasing its fees. Thank you, sir. We are delighted to have you. Would like you to give a welcome address to the participants. Thank you.
Okay.
I would also request Ms. Hiteshi Trivedi to just welcome the sir and felicitate. A round of applause, please. Thank you, sir. So you can speak from there if you want.
Okay. Whatever, it hardly matters. So for the first thing, till yesterday my speech was 5 minutes. From this morning it suddenly increased to 15 minutes. So if you feel me not fully prepared, just pardon me for that. Having said that, see, from my perspective, from my side, in fact, I attended the last 1 hour or 45 minutes of the session that was going on deliberately instead of coming at the last minute, because honestly speaking, though I have held the IP portfolio in the Delhi High Court for 3 years now, over 3 years, Mr. Varun Sharma would bear me out on that, I have very little knowledge of the subjects which are under deliberations today. Honestly speaking, in 3 years, I have not come across a single case till now. In 3 years, where we have had to grapple with, please come, sir. We have had to grapple with the effect of AI in IP, protection of AI-generated inventions, dealing with AI-generated issues in IP, and in fact, I am a bit of a novice even in blockchains. So this whole, what the gentleman had put, I don't know his name, I'm very sorry, he put a query as to whether a chat GPT generated, if there is a chat GPT generated material, who would be the owner for the purpose of copyright? That's a very interesting question. And what Mr. Pankaj had said about if it comes before me, yes, I would be very happy to deal with it. Having said that, as I said, for the past 3 years, I have not come across any case which has an AI angle at all. So I don't know how long I will continue to hold this jurisdiction. So if it does come before me, rest assured I will decide it, rightly or wrongly. And whether they want to follow it or not is their decision. But we have dealt with IP, so you'll be, whatever I am saying is from a very raw perspective. You've been hearing persons who are in the thick of things, who are actually IP experts, who are dealing with it at the executive and at the governmental and at the operational level, who deal with it at the raw basis, at the raw level. We as judges, we only administer the law as it exists. So we have the section of IP statutes. We have the Trademarks Act, Copyrights Act, Patents Act. Now we have, so the only real arena in which AI to some extent has made an inroad into case law which we are dealing with is probably in the IT guidelines, which they have already referred to. And Rule 3 was referred to, Rule 3 of the IT guidelines. Even Rule 3 has definitely come up for consideration before me on quite a few occasions. And I have also had occasion to say something about Rule 3, because Rule 3 also comes up for various challenges. The whole question of who's an intermediary, that itself is now a question of debate. There are invariably, if one person calls himself an intermediary, another side says he's not an intermediary. Once you can call yourself an intermediary, how far can you be policed by the intermediary guidelines is another issue. Whether Rule 3 violates the safe harbor provisions in the IT Act, that's another issue. And there are certain issues. For example, if you go by Rule 3, it says that a person who is an intermediary is also supposed to take steps, appropriate steps, in order to ensure that his channel or whatever is not used for posting infringing content which infringes IP rights, etc. So then the whole question arises as to whether he will be the decider as to whether the content is infringing or not. So there are various issues which come up for consideration, and these, we have had to deal with it so far at a very raw level. And I think even at the international arena, so far as the judicial part of it is concerned, there is really no definitive legal position on the interaction between AI and IP. In fact, rather coincidentally, my very first address to any such conference after I joined as a judge was in this room, where I had been invited by Professor Shamnath Bashir. Many of you would be aware of him. He was a very dear friend of mine, and he invited me to give a talk incidentally on AI. On AI's role in deciding cases and in administering justice. And I was very dismissive of it at that stage. I said, no, AI is all hocus pocus. And I mean, this was of course 6 years ago. And I said, AI can never substitute the human element, and how can AI take a decision? After all, dispensing justice is not dispensing with justice. So it involves a subjective element, it involves considering merits, it involves an emotional element, it involves so many factors which a machine can't do. So that was my raw decision at that stage, and Professor Bashir told me, you just wait for 3 years and see if the same view would be taken. And I see that the whole thing has changed in 3 years. Today I found a book called The Metaverse, which is written by someone, and that if you read that, it's fairly scary. So we have to take the pluses and minuses of AI and somehow integrate it with IP, because as I see, IP and AI will actually go on parallel tracks, and each will fight for supremacy. Because IP also, people who ask for protection of IP rights seek to protect them very assiduously. So to what extent AI generated content can be protected, to what extent AI will interfere with protection of IP rights. These are all matters which are which are extremely complex, and from the point of view of a judge, I mean, we are still in very virgin territory, and I really don't know if within at least I don't think it will be during my tenure on the IP portfolio, but even within a reasonable prospective time, we will be able to put down any actual, binding jurisprudential principles in these. But yes, it is a wonderful study, and I myself am now trying to read up on, because we get frankly very little time after our judicial work. But after that, whatever time we get, I am also trying to read up on AI, and that's why, as I said, I came 45 minutes later so that I could learn something about it. And so, I mean, I have after me Mr. Kant, who is a much better authority than me to speak on these aspects. But yes, I do envisage that AI and IP would be a major challenge in the days ahead, and the extent to which, as I said, it will basically be in the fields of copyright and patents rather than trademarks, etc. And the extent to which AI-generated inventions are patentable, as they said, AI-generated inventions today, there is no provision in the Patents Act to protect AI-generated inventions, because first of all, there will possibly be even a question of who will be the inventor. But all that will come up once we start identifying and giving a face to AI. Then probably, because AI today is in a nebulous, it's an intangible entity. Once we can give a face to AI, then it will be much more possible to modulate IP rights in the AI sphere. And till then, I suppose we will just have to keep discussing it and watching how the world jurisprudence develops, world and Indian jurisprudence develops in that regard. I am extremely thankful for having been called for this. And as I said, had I known that I would have to speak for a greater length of time, I would probably have been better prepared. But thank you very much. And as I said, if any case does come before me during my tenure on the IP roster, then definitely I will look into it. Thanks a lot.
Thank you, sir, for your valuable insights. With a big round of applause, we would like to welcome our chief guest for this conclave, Dr. Shri Amitabh Kanji, G20 Sherpa of India. Thank you so much, sir, for your presence. For the benefit of our participants, everybody knows Mr. Amitabh Kant. He is presently the G20 Sherpa of India. Under his able leadership, India showcased an outstanding presidency in the G20 summit held at New Delhi, has been applauded as the most.
Let's move with the program.
Okay, so would like to welcome you, sir, for your keynote address. Thank you so much. I would request Hiteshi to kindly welcome, sir.
Honorable Justice Hari Shankar, MS Gabriel Mosla, Ms. Hitashi Trivedi, all the distinguished guests, all those who've participated in this intellectual property talent search exam. This is the 6th such venture, so I really want to compliment the organizers for this very unique initiative to promote intellectual property rights in this country, and to have a conclave of this nature, and to have regular talent exams so that people are made aware of IP rights in this country. I think it's very critical if India is to grow at high rates of 9 to 10% over a long period of time, the next 3 decades.
if we have to become a $35 trillion economy by 2047, and if we have to lift vast segments of people above our poverty line, then innovation is very critical. No country has been able to grow without innovation, whether you look at Korea, which grew at 10% for about 2.5 decades, or whether you look at China, which has grown for 3 decades. Innovation has been a very key component in all this. And constantly being able to get IP rights in a country is really demonstrates a country's ability to push for innovation. And therefore, the government has taken a series of measures. Earlier, it used to take a very long time. It used to take 6.5, 7 years to get your IP registered in this country. We've brought it down to the same level as USA and Japan now. And this has been possible because we've taken a lot of technical examiners in this country. We are now again, this process had slowed down. Now we have again done a vast amount of recruitment to ensure that the patent office is constantly updated, constantly modernized in terms of technology, and is kept abreast of all the best practices that are happening across the world. That has been the endeavor of the government. We've also done a vast range of things, one of which is that we've driven the startup movement in India. When we started the startup movement in 2016, there were just about 156 startups in India. Now there are about 110,000 startups. We have over about 120 unicorns in this country. Thirdly, there's been a huge process of innovation in this country by the fact that we've given a digital identity to everyone. We've seen that everybody has a bank account. We do 46% more mobile fast payments as compared, 46% of the real-time payments in the world are happening in India. But what has happened as a consequence of this is that a lot of startups have done innovation because of the tech infrastructure that has been built up in this country. So you are seeing a number of startups like MobiQuick, Pine Labs, etc., all doing cashless, paperless credit. Then you've seen a new set of startups who have taken stock market into rural areas, tier 2, tier 3 cities. So Zerodha, Grow, Upstock have all taken innovation into these areas and brought people from tier 2, tier 3 cities to be active participants in wealth creation. And then you have another set of startups like Digit and Acco who've providing insurance on the go, on your mobile. And when I was a young officer, it used to take 6 months to get an insurance policy from LIC. They gave insurance on the go in 30 seconds flat. So what India has seen is a lot of technological innovation in recent times. And now we are linking up artificial intelligence and ChatGPT to digital public infrastructure. And digital public infrastructure which India has built is all open source, it's open API, it's open standards, and is interoperable. But on top of that, when you link up AI and ChatGPT, as we've demonstrated in Bhashni, and this Jugalbandi app demonstrates that even in rural areas, India has 22 official languages, over 1,700 dialects. Anybody can speak on voice in his local dialects, can get access to any government scheme, will get access in voice to all the government forms, and can apply for any government scheme in his local language, and is able to get the benefit of government schemes through Bhashni using AI and ChatGPT on top of the digital public infrastructure. So that is the kind of innovation that is happening now, and you will see a huge amount of innovation in the coming years because the country has driven a lot of disruption
through the Startup India movement and through the use of technology. Now, much was talked about AI. To my mind, the march of AI will be inevitable. It's a very foundational technology, and therefore it needs to be used for the good of humankind. It needs to be used for the good of sustainable development goals. How we are able to use AI to improve learning outcomes, how we are able to use health outcomes, how we are able to use nutritional standards in India, so that the AI as a technology is able to benefit the citizens of India, rather than using AI for defense and many other sectors. There are challenges on algorithms, there are challenges on ethics, there are many other challenges of AIs which will spring up, what India has demonstrated in DPI is that we've kept everything open source and open API. And to my mind, the basic assumptions and the open source nature of DPI has led to a huge amount of progress in India. It has enabled much more innovation to take place because it has been interoperable. And I think the same model and the same principles need to be carried forward in artificial intelligence in the future, so that we make it open source and enable much more innovation to take place using the power of AI. India can greatly leapfrog because India has vast amount of data. Every Indian throws up huge amount of data. We have anonymized the capacity to be able to do anonymized data. India also has great computing power now, which is essential for the use of AI. And Indian software engineers have the great ability to build algorithms. So in all these many areas, I think a huge amount of disruption is taking place. We are now getting into a range of sunrise areas of growth like electric vehicles, advanced chemistry cell battery, semiconductor, green hydrogen. All these are sunrise areas of growth which are very critical for the country to grow and expand in. So I think the next 3 decades will be the decade of innovation. I am a great believer that without innovation it will not be possible for India to grow, and therefore we have progressive and forward-looking judges like Justice Hari Shankar, who will assist in spreading the cause of innovation, spreading the cause of intellectual property rights, because the country needs to grow on the basis of foreign investments and FDIs as well. And for them, IP rights are very critical. I would like to again congratulate the organizers for doing this IP talent search exam and for doing this, doing several conclaves of IP. This is a very unique initiative, and to spread the message of IP and to create new talent in India. So my congratulations to all of you, and I wish you all the best and all success. Thank you.
For your presence and insights. This has added immense value to the discussions, elevating the overall quality of this conclave. Your address was truly inspiring. Your contributions have left a lasting impact on all our attendees and undoubtedly contributing to the success of the conclave. Now the most awaited award ceremony is to begin. With a big round of applause, would like to invite both our chief guest Shri Amitabh Kanji and our guest of honors Justice Hari Shankarji to kindly felicitate our winners with certificates and trophies. Would like to invite them. And Ms. Gabby also.
Hi, good evening. Am I audible? Yeah, so we'll just begin with the school category first. For the first rank, we have Ragi Sharma from Gauze International School, Greater Noida. The second rank we have Anurag Sriram Swaro from Modern English School, Jaipur. At the third rank, we have Harsh Sharma from Everest Higher Secondary School, Bhopal. Moving on to the university category, we have rank 1, we have Mr. Krishanshu Kapoor from the University of Delhi. At the second rank, we have Miss Isha Parande from the Marathwada Law College, Pune. Mr. Puneet will be receiving the award on her behalf. At the third rank, we have Miss Prachi Mudholkar from the Cummins College of Engineering, Pune. Moving on to the faculty category, also we would like to invite Mr. Pankaj Soni, partner Reference Sagar, to felicitate the winners. Please, sir. In the faculty category, the winner is Miss Akansha Dwivedi from the Acropolis Institute of Pharmaceutical Education and Research. She will also be receiving the award on behalf of the Sigma School of Excellence as well as the youth leaders from IPA, and Miss Rakhi Khabia from the youth leader category. In the working professionals category, we have Mr. Bhuvnesh Sharma from Honda Cars, India. This award will be received by Mr. Nischay on his behalf. In the startup category, the winner is Mr. Sanidhya Chaudhary from Your Legal Advisor. The award will be received by Mr. Sachin on his behalf. In the university category, we have the Acropolis Institute of Pharmaceutical Education and Research from Madhya Pradesh. The award will be received by Dr. G.R. Dharvedkar, who is the director of the institute. Moving on to the domain-specific winners. In the first domain, that is design and architecture, we have Miss Kritika Binjwa. The winner is Kritika Binjwa from the Acropolis Institute. The award will be received by Miss Akansha Dwivedi. Miss Dwivedi will also be receiving the awards in the other two categories, which are hospitality and mass communication. The winners, yeah. The next domain is engineering and technology. The winner is Baba Saheb Ambedkar Technological University. It will be received by Mr. Avinash Ingle. Mr. Ingle will also receive the award on behalf of the PES College of Engineering as well as the Baba Saheb Ambedkar Technological University. The next domain is law with IP specialization. The winner is Mr. Harsh Raj from Chanakya National Law University. The next domain is law without IP specialization. This is the winner is Miss Avantika Mahajan from the University of Jammu. The award will be received by Mr. Harshit Jain on her behalf. The last domain is research and science. The winner is Miss Astha Bhavsar from the B.R. Nahata College of Pharmacy. Miss Astha, okay, she's not here. Moving on to the last category for the day, this is IP recognition in academia. The first, so we're just pleased to inform you that out of the applications received, the winners have been shortlisted on the basis of the contributions in the field of IP, the total patent filings, as well as the number of patents granted. So the first one is Miss Debabrata Bej, Senior Research Fellow at the National Institute of Technology, Durgapur. Next we have Miss Nidhi Booch. She is the head center for IPR at the GNLU Gandhinagar. Miss Michelle will receive on her behalf. Next we have Dr. G.N. Dharvedkar, who is the director of IPR. And the last awardee for the day is Mr. Jatin Dahiya, who is a student at the North Cap University, Gurugram. Thank you all for being a wonderful and a patient audience.
Okay, so just to, that brings us to the end of the award ceremony of today. I would just like to conclude that India has always been a land of thinkers and inventors, and now more than ever, we are witnessing an incredible surge in technological advancements, scientific breakthroughs, and creative endeavors. This conclave has been a testament to the commitment of our nation towards fostering an ecosystem that nurtures and protects intellectual property. Now, as we bring the curtains down of this conclave and award ceremony, I wish to thank each one of you for your collective efforts and involvement. First and foremost, I extend our deepest thanks to our chief guest, Shri Amitabh Kant sir. He had to leave due to paucity of time. Our guest of honor, Honorable Justice C. Harishankarji, our incredible speakers who have shared their expertise and insights enlightening us all. Your valuable contributions have undoubtedly enriched our collective knowledge. A special acknowledgement is due to our esteemed partners and sponsors whose unwavering support has been instrumental in making this event possible. Their commitment to the ideals of IP Conclave and IPTSE Awards has not only enhanced the quality of our discussions, but has also contributed significantly to the overall success of the conference. Let me take a moment to express our heartfelt appreciation to our knowledge partner NASCOM, our knowledge partner CPAM, conclave partner NASCOM, our industry partner Ericsson, lead partner Remfry and Sagar, and our associate partners like Zorbis, KNS Partners, Singh & Singh, Qualcomm, and TCS Consultancy Services. Government support organizations, Ministry of Electronics and Information Technology, PSCST, NRDC, and CED, Government of Gujarat, for their support in making this conclave successful. I would also like to extend our gratitude to our organizing committee, volunteers, and everyone who has worked tirelessly behind the scenes. Your dedication has not gone unnoticed. This conclave would not have been possible without your hard work and commitment. I would now request all of you to please join us for the networking dinner. Thank you.